yesterday. Full stop. In your the above, comma, the cases stand adjourned for 2 weeks.
Lordship,
Office to list the case.
Lordship, item number
Cases
37.
one.
Item number 37, WPC 199, Lordship. We are entering appearance only today, and then we haven't received a copy of the petition yet. So the same may be.
Who is the counsel for the petitioner?
Judge Jimmy, Lordship.
Office to list the office to list weeks on it to fix by the office. Mr.
Abel IME.
Abel IME, learned counsel for the petitioner in
Yes.
WBC number 199/2022 shall furnish a copy of the writ petition along with annexures to MS
Ubang Menla Longcha.
counsel, junior government advocate
No, Lordship, for the private respondents.
for the private respondents within 2 days.
Yes, Lordship.
May it please your lordship.
Yes.
My lord, the item number 45, which was part heard yesterday in the supplementary hearing list. I beg the lordship to, if possible, to upgrade the matter, my lord. So that
Okay,
the
after the
matter-
admission matter, we'll try to pick up.
My lord.
After the
Lordship.
admission matter.
Lordship.
After the admission matter.
My lord, my lord.
Please, your lordship. Your lordship, I beg to mention here in item number 39.
39. Yes, madam, you are
No,
for
I
the
beg that
petitioner.
This matter be listed after 2 weeks.
You are for the petitioner.
Yes, I'm for the petitioner.
MS
Victor,
V. Terry, any Terry, learned counsel for the petitioners. Has paid for listing of the case after 2 weeks. Who is for the respondent?
Lordship, I am appearing on behalf of my main counsel P. Sharon.
Okay. So it is
So,
submitted, MS, Mr.
Parkin Babu.
Parkin Chabo,
Chapakin Chabo.
Parkin Richabo. Learned counsel for a private respondent. Who is in attendance, comma, has submitted that he has no objection to a said prayer. As released the case. The praise allowed release the case after 2 weeks on the day 2 weeks.
and your lordship, I beg to mention item number 1, petition item
Item number
1. Lordship, here I have received the affidavit filed by the state only this morning, your lordship. So I may be given some time to peruse and file.
okay, let the matter call up. Any other mention?
So, Lordship, I beg to mention item number 15 to 19.
15 to 19.
Lordship,
Yes.
in these matters, we were praying for regularization and minimum scale of pay.
Hmm.
And in 2 of the matters, the clients have been regularized, Your Lordship. So kindly grant us 1 week time to seek instructions.
In 2 of the
Yes,
cases,
Your Lordship. In item number 15 and 16.
15 and 16.
Yes, we were informed today, Your Lordship.
Okay, you want to take instruction.
Yes, Your Lordship.
Okay. Next Tuesday?
Yes, Your Lordship.
Okay. Hurt MS
And so,
and Solo, learned counsel for the petitioners and MSP Supri, learned additional advocate general learned for the respondents. Post of Ms. Provincial, learned counsel for the petitioner has submitted that the petitioners in WBC number 2, she has received information that the petitioners in WBC 203/2023 and WBC number 200/2023 have been regularized during the pendency of the petition. She has thus paid for listing of the cases on Tuesday next in order to complete her instructions. List the cases accordingly.
Yes, your lordship. Lordship, I would like to mention item number 11, lordship.
11.
Lordship, on behalf of Abitoli, if this matter can come out after 2 weeks, lordship.
You're for the state.
Lordship,
Any petitioner? You have informed. You have informed the petitioner. Okay, your name please. Hmm?
It's
Okay, so and so learned counsel for the petitioner is present. MS. So and so learned counsel, learned state counsel appearing for.
2 weeks, Lordship.
You are the counsel. You are the state counsel here.
Lordship, I'm appearing on behalf of Avitoli, Lordship.
Okay, Abitoli,
Lordship, there's the agent.
representing MS Abitoli, United State Council. As paid for listing of the case after 2 weeks. As the prayer is not opposed by the counsel for the petition, the prayer is allowed. This is the case after 2 weeks, so we need to be expect of this. The interim order, if any, shall continue till the next day.
Lordship, I also like to mention item number 9, Lordship, on behalf of S. Mary, Lordship. If this matter can come up after 4 weeks. Affidavit has been filed, Lordship.
Affidavit?
Has been filed.
Okay.
If this matter can be fixed for admission hearing on Friday.
Friday,
Yes, Your Lordship.
not Friday, maybe Thursday?
Lordship, after 4 weeks, Lordship.
4 weeks is too long, Your Lordship.
You have filed your affidavit,
Lordship,
then what is the difficulty? After 2 weeks,
Lordship.
Lordship.
MS
Aratsla case.
Tips, learned counsel for the petitioner is present. On the prayer of Miss so learned state council, release the case after 2 weeks.
Obliged, my lord.
Lordship, I also like to mention item number 9, 13, Lordship, on behalf of S. Mary. If this matter can come up after 1 week. Item 13.
Yes. Mr.
Mr. Jiwala.
Joalo,
Yes, madam.
Jiwalo upon,
Yes, madam.
learned counsel for the petitioner is present. MS so and so learned its senior government advocate. Representing S. Mary,
Lordship,
learned senior government advocate
Lordship.
has paid for, paid on behalf of the state respondents. Release the case after 2 weeks. As the praise of the Minister upon learned counsel for the petition. Release the case after 2 weeks, 4 weeks or
1 week, Lordship.
one.
Lordship, I also like to mention item number 20, 21, and 22, Lordship.
20, 21, 22.
Lordship, on behalf of S. Mary, Lordship, and Locus matter. This matter.
What
can come-
happened to S. Mary?
Lordship,
She is disposed or what?
Lordship,
Huh? Petitioner?
Contingent, Lordship. He's out of station.
Mr.
Contingent.
Client Counsel. Representing Mr. Toshi Tenyam, congener, learned counsel for the petitioners. Yes, present. Representing S.
Yes.
Mary. Senior government advocate has submitted that S. Mary has some personal difficulty. Complex cases. Okay. And has thus paid for listing of the cases after
4 weeks, Lordship.
4 weeks.
Lordship,
Okay, 4 weeks. The prayer made on behalf of the state respondent is allowed. Place the cases after 4 weeks.
Lordship, I also like to mention item number 24, Lordship, on behalf of regional, Lordship. If this matter can come after 2 weeks for hearing, Lordship.
24,
Lordship. After 2 weeks.
you appearing on behalf of whom?
Regional,
V. Jimom.
Lordship.
Mr.
One equally.
Learned counsel for the petitioner is present. MS Renfro. Learned junior government advocate. Representing MS V. Jimom. Learned State council has paid for listing of the case after 2 weeks.
Your Lordship, for the respondent, will 5 the accounting
Okay.
general.
and Mr. J. Seki, Learned Counsel for the respondent number 5 are present. Huh? Prayer made on behalf of the state council is allowed. It is the case after 2 weeks.
Lordship, I also failed to mention item number 23, Lordship, on behalf of Inavali. It is matter can come up after 2 weeks for hearing, Lordship.
Inavali.
Inavali.
Inavali. Yes, Mr. Solo. Learned Counsel for the petition is present. Same thing, representing Inavali. Learned State Council. How much time?
2 weeks, Lordship.
Okay, to say, repeat, change the name Inavali.
Lordship, I also failed to mention item number 38 on behalf of Livika. If this matter-
Livika.
Livika, Lord. If this matter can come up on 21st of March. Yes, the Lordship.
What is Jamil Learned Counsel for the petition is present on the prayer of Ms. So-and-so. Learned Junior Government Assam representing MS Livika, Learned State Council. List like it's on Thursday.
21st. Lordship, I also failed to mention item number 8, Lordship, on behalf of my MP. If this matter can be fixed on 22nd of March.
Okay. On the prayer of Ms. So-and-so representing more Incheon,
My MP.
Learned State Council. List the case of 20.
22nd. Lordship, similar prayer for item number 40 on behalf of my engine.
40.
Lordship,
See? What is Jamil? After a week. Mr. Watijami, as agreed to by Mr. Watijami, Learned Counsel for the petition and MS so-and-so, Learned State Council, the list the case after a week. After a week.
Next, Lordship.
To mention item number 6, Lordship, on behalf of Sir P.P. Paul. We have submitted an adjournment request, Lordship. It seems he's out of station, Lordship, for some personal work. But it is made come after 2 weeks.
You are praying on behalf of
P.P. Paul,
Mr.
Netovero, on behalf of P.P. Paul.
Learned Counsel, paying for Mr. P. Mom.
Yes.
You are for the respondent or petitioner?
It's your Lordship.
Petition.
Yes.
As straightforward listing of the case after 3 weeks.
Yes, Lord.
As a mentioned memo has also been circulated to that effect yesterday, command of prayer is allowed. It's after 3 weeks.
It's an interim, Lordship.
The interim order, if any, shall continue till the next.
Item number 7, Lordship. Item number 7, on
Hmm.
behalf of Toshi Temjen.
Hmm.
He's out of station, Lordship. So I pray this matter may come after 3 weeks, Lordship.
Okay, Mr. So-and-so, Learned Counsel appearing for Mr. S. Temjem,
Toshi Temjen.
Tosi Temjem, Learned Counsel for the petition. Submitted that Mr. Tosi Temjem is out of station on personal ground and has thus paid for listing on the case after 3 weeks. It is submitted that consent has been taken from the Learned Counsel for the respondents to make aware.
Similar prayer for item number 12. Similar prayer.
Item number
12.
12.
Yes, Lordship. Similar prayer.
Similar prayer, same.
Reply tomorrow.
Please, Your Lordship. Your Lordship, I beg to mention item number 14.
Yes.
Lordship, here I'm here to file a reply to the respondent number 2, 3, and 4. So, Your Lordship, sometime will be given.
How much time?
2 weeks. Your Lordship.
Lordship, this is an urgency, this matter, Lordship. The matter pertains to NPA, non-practicing allowance. Now, the petitioners are all serving as doctors under the government of Ireland, and they are getting the benefit of NPA. And since there was a direction of government doctors doing private practice, so a notification was issued, restraining them from doing private practice. Now, they have challenged that notification.
And in interim order.
And there is no interim order, Lordship.
Then, if there is no interim order, what is the hurry? If 2 weeks, agree to a date.
Lordship, yes, it is.
MS
Vitere.
V. Learned Counsel. Learned Counsel for the petitioner has prayed for and is granted 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the respondent number 2, 3, and 4.
Lordship.
As Mr. N. Mojuri, Learned Counsel for the respondent number 2, 3, and 4, has prayed for a fixed date expressing urgency in the matter. As agreed to by the Learned Counsel for the parties, lays the case on 4th of April 2000.
Lordship. Obliged, Lordship.
This Lordship. Lordship, I beg to mention item number 10. Lordship,
10.
Lordship, 2 weeks' time may be granted to file affidavit in reply to the affidavit in opposition filed by the government as well as the respondent number 5.
Mr. Swenson, Learned Counsel for the petitioner, has prayed for and is granted 2 weeks' time to file affidavits in reply to the affidavit in opposition filed by the state respondents and to the affidavit in opposition filed by the private respondents. Release the case after 2 weeks.
From the supplementary cost list for withdrawal, item number 41.
I have an instructions from the petitioner's lordship to withdraw the petition.
MSR Atsula Kips.
My lord,
Learned Counsel for the petitioner has submitted on instruction, that the petitioners want to withdraw the petition. Any state council
your lordship, I may be withdrawn with the liberty to file afresh.
with the liberty to file afresh. Any state council? MS
Yes, John.
has a chance. Learned Junior Government of Assam for the state respondents. In view of the above submission made by MS Gibbs, Learned Counsel for the petitioners, the petition is dismissed on withdrawal, with the liberty, as prayed for.
Much obliged, my lord.
For motion, item number 42.
Mr. Lordship. Lordship, by this petition, the petitioners are, when his lordship direction to pay the bills against the work, the contract works that was executed by the two petitioners here. Lordship, the Ministry of Urban Development by Office Memorandum 4/3/2014, central assistance was granted to the state government to develop certain works and especially the road in small and medium cities in the state of Nagaland, by which the state government have issued NIT. And the two petitioners that have participated and been qualified, they were awarded the contract works, to which even there was a conditions in the work order that 25 months, that contract period was given to the petitioners. If they fail to perform it, then they will be penalized. So Lordship, accordingly, that as soon as the work order has been issued, according to the specification of the work order, and after signing the contract agreement, the two petitioners, they have executed the works. And in between, they have sought even the state government, they have written to the ministry to release the amount. The release amount, that is 50% of the amount, so that they can continue their work. But despite of which, that was not done. And since the amount cannot be, the ministry cannot release the amount 50% before 30th of March 2014. The ministry has communicated to the state government that the project has been dropped. So this is the.
What happened? Did you complete it? No.
No, Lordship, only 71% of the scope of works that has been completed. Lordship, for that matter, Lordship, may I take the Lordship to page 32. Page 32. This is the details of works completed, issued by the executive engineer. Then Lordship are more specific in page 36. Page 36. The Director Urban Development had written to the Secretary Urban Development Department, Nagaland, seeking for allocations of fund. Lordship,
Both of you had executed 71%.
yes, Lordship, total. Lordship, it will be, the comparative statement will be found in page 32.
You can issue notice at this stage.
Lordship.
Heard Mr. Kekshi in Yuli, Counsel for the petitioners, NMS Solo,
Yes, Chang.
Chang, Learned Junior Government with Assam for Nagaland for the response number
1 to 4, Lordship.
1 to 4. Anybody from CGSC? Mr. Wangarvati, Learned Central Government Council for the response number 5. The two petitioners have stated that they are registered contractors and pursuant to a bidding process initiated by a notice inviting tender dated 24/5/2014, they have been awarded 2 contract works. PIJ development of town lanes for ward number 4 Dimapur within bracket package 1. No. Development of town lanes for ward number 4 Dimapur package 2 to petition number 1. The development of town lanes for ward number 4 Dimapur package 1 to the respondent number petition number 2. The work orders were issued in June 2014. So according to the petitioner, the contract value of the 2 works are 240.34 lakhs and rupees 240.55 lakhs respectively. After issuance of the work order and signing of the contract agreement, they proceeded to execute the contract works. And till date, they had completed 71% of the contract works, amounting to contract value of rupees 1,72,206.94 for package number 1 and rupees 1,78,446.68 in respect of the package number 2. But despite submission of running wheels, you did not submit any running wheel.
No,
Then how? You are not claiming anything.
no, Lordship, we have submitted. Lordship, page 22.
Okay. Did you submit wheel or not?
That will be submitted by the engineer.
Agreed by non-release of contract amount, at least in part. Petitioners are before this court. Issue notice returnable in 4 weeks. As MS so-and-so has appeared and accepted notice on behalf of the respondent number 1 to 4 and Mr. Ingravati and its Central Government Council has appeared and accepted notice on behalf of the respondent of 5, the issuance of formal notice stand dispensed with. Full stop. Learned counsel for the petitioner shall have a furnish requisite number of extra copies of the petition to MS so-and-so and Mr. Angarbati within 2 working days from today. This is the case after 4 weeks. The respondents shall file their respective counter affidavits in the meeting.
For admission, item number 1.
Please, Your Lordship.
Oh, you made a prayer.
Yes, yes, Your Lordship.
Yes. But
Yes.
what was the prayer?
Your Lordship, the state has filed their affidavit, so Your Lordship, I may be given some time to
Okay.
and file in reply if necessary, Your Lordship. I've received their affidavit only this morning.
Okay. Who are the Mr. Imtim Chen?
It's not number 1 and 2. Step by step.
And Mr. Ingravati for
Unanimous.
MS
Be today.
V. Terry.
Yes, Your Lordship.
P. Terry. Heard Mr. P. Terry, learned counsel for the petitioner, Mr. Imtim Song, learned additional advocate general, Nagaland, for the respondent number 1 and 2, and Mr. Ingravati, learned Central Council for the respondent number 3. MS Terry has submitted that she has received a copy of the counter affidavit filed on behalf of the respondent number 1 and 2 only today.
Yes, Your Lordship.
Full stop. MS Terry has thus sought for 2 weeks' time to go through the affidavit and to file a reply affidavit
Yes.
if so advised. Full stop. The prayer is allowed is the case of the 2 weeks.
Your Lordship, there is an interim, so it may kindly be
The interim order passed, I guess, will continue till the next.
extended.
For admission, item numbers 2 to 5.
In all the cases? In all the cases? Yes, now? How much time? 3 weeks. MS. Chris and you. Learned counsel for the petitions, heard, and MS. Bichano, learned junior government advocate.
Lordship.
Nagaland for the state respondents, full stop. MS. Chris and you has submitted that counter affidavits on behalf of the state respondents have been received only today,
No.
received recently.
Yes, sir.
Full stop. She has thus sought for 3 weeks' time to go through the counter affidavits and to file affidavits in reply to those counter affidavits if so advised. The prayer so made by MS so-and-so stands allowed to release the cases after 3 weeks. Then yesterday's
For hearing.
adjournment. Yesterday, Yesterday. Huh? Huh? These two we have had. These also I don't know. Yes, hearing matter.
For hearing item number 45.
Received.
Yes, yes, Your Worship.
The other judgment in the writ petition and the writ appeal. Other judgments in the writ petition and writ appeal are not directly applicable. The other judgment in the writ appeal and writ petition are not directly applicable. Not directly applicable. One minute.
Petitioner as well as the respondent, they have applied for more than one post, if Your Lordship see it.
That issue is regarding petition respond number 8, I think, yesterday. Yesterday.
Yes, yes, he has applied for welfare organization.
Where is respond number 8? Let us see that where is the dispute.
He has applied for UPA, LDA, and welfare organizer, Your Lordship. Respondent number 8.
8.
Yes. He has applied for UPA, LDA, and welfare organizer.
What is his name? What was the ground of challenge in respect of respondent number 5?
He's from technical trade, Your Lordship. He's a petty officer. And the qualification requires in the advertisement should be clerical in trade, Your Lordship. He's a petty officer.
Just ground of challenge. What was your challenge as regards respondent number 10?
He's in a lower rank, Your Lordship.
Huh?
He's in a lower rank. He's ninth. He's
Right.
yes. And he's only MSCP Havildar. That is, he's enjoying the salary of a Havildar, but his actual rank cannot be an Havildar.
MSCP.
Yes. With the application of the salary was given to him.
Keep those with you. I have just checked. And checked. What is the substantive post of petition number 5?
Clerk Havildar, Your Lordship, Havildar clerk.
Where from you are saying?
Your Lordship, that was the clear
Where from
instruction
you are
that
saying?
I cannot produce the documents, but they are Havildar clerk, Your Lordship.
Huh? Don't think so.
No, Your Lordship, the instructions are clear, they are Havildar clerks, all the petitioners. They were working as Havildar clerks in their service, appointed to that particular cadre.
He is clerk,
Yes, Havildar, Your Lordship.
but
Yesterday, the
Yes, yes,
petitioner's
yes.
document was also directed to be produced by the government, so
it is there. He is the father. The father is equivalent to clerk. Okay, Mr. Seki, you go through this petitioner's credential. Then go through petitioner's credential. Have the satisfaction whether they are eligible or not eligible to apply. If they are not eligible to apply, they cannot maintain the writ petition. Right?
Your Lordship.
Right? If they are ineligible, they cannot maintain the writ petition, matter close.
My lord.
Get the satisfaction.
The petitioner number one, Lordship, is qualified to reply. Selection part is a different issue, Lordship.
Clerk,
Yes, Lordship. As a
Yes,
clerk.
he's
Under
clerk. MSCP Naib Subedar.
Yes, Lordship.
He is clerk.
He can be
MS
treated as GSU also.
Who is ZCO, who is NCO, I don't know.
Lordship, Naib Subidar.
Naib Subedar is apart and
Yes, Lordship.
hired and clerk.
Yes, my
So
lord.
his petition number one is clerk and MSCP Naib Subedar.
Yes, Lordship.
So he is eligible to apply.
In fact, both as GSU and if we go by the system
Ah.
maintained, both as GSU as well as.
No, MSCP Naib Subedar is not, he gets the pay scale of Naib Subedar, but he is not promoted to the substantive post of Naib Subedar. So he is substantially his clerk. Find out who is
No.
Havildar clerk or not.
Yes, he can be treated as 100 clerk, yes.
He is eligible to apply.
Yes. As
Let
far
us
as his eligibility to apply is.
Petition number two. See also their date of discharge.
Your Lordship, as far as the date of discharge is concerned,
No, see, I have said
Yes.
just date of discharge. I have not asked you to make argument on it.
my lord. Yes, yes, Lordship. My lord, my lord.
Whether they are after or before. Check that one.
Yes, Lordship. This is 30th September. 2000. Petition number. My lord.
He is Havildar clerk. Petition number two.
Yes, petitioner number two also is
Date of discharge. Okay.
date of discharge 2015. my lord.
Below 55.
Yes, your Lordship.
Who is okay?
Okay, your Lordship.
Three.
Yes, my lord.
Havildar clerk.
Yes, I will do.
Date of discharge.
Two 2017. Petitioner number three, my lord. Yes,
Havildar clerk.
Havildar clerk. Clerk staff duties. My lord.
Four.
Yes, my lord.
Havildar clerk. MSCP Naib Subedar.
Date of discharge 2019. My lord. Petition number four.
MSCP Naib Subedar.
Yes, Lordship.
Petition number five. He is not Havildar. So I reverted back to your page 97. He is the father,
Yes, Lord.
the father clerk,
That's okay. Yes, Lord.
page number 5, page 97. The father stroke Adilda. He is the father clerk. I don't know what is the difference between the Adilda and the father, but he is the father.
My lord.
Date of discharge,
Lord, I'm hearing you. Date of discharge, 31st March 2017.
so they were eligible to apply.
As far as eligibility is concerned, Your Lordship,
They were eligible.
eligible to apply.
Now let us come to petition respondents.
Hello.
Take respondent number 4. Tag mark is there. Respondents document applications.
My lord.
Mess free. One by one you can give so that tags are not misplaced. Respondent number 4.
Yes, Lord.
What is he?
The sergeant.
Sergeant. That means he is in Air Force.
Yes, Lord.
What is his date of discharge?
My lord. Date of discharge, it's 30th June 2020.
Sergeant is equivalent to Havildar.
Havildar.
Now, respondent number 5.
Date of discharge is 31/7/2018.
That is okay. 31/7.
Yes, Lord. 2018.
What is his post?
The post in which he is appointed,
No, post which from where he is discharged. Petty officer.
petty officer, yes, Lord. He was in the Navy, Indian Navy. Served as a petty officer, which is the rank of Havildar.
But is there anything appearing as clerk?
Your Lordship may kindly appreciate the documents that I have annexed.
We appreciate. Is
Yes,
there
sir.
anything? I'm just looking. We are considering
Yes,
on the
Lordship.
applications.
Now, as far as the mention of,
Clerk word is appearing or not appearing? I want Mr. Seki to be entirely satisfied
my lord,
before starting his submission.
my lord. As far as the word clerk is concerned, Your Lordship, it is not mentioned.
Your document says that you are aircraft fitter. Petty officer, aircraft fitter. Respondent number 6.
I was having a look at the document, Your Lordship. What did the respondent number 5?
This document is at page 22 of your affidavit.
It starts from page 22.
Down below. Petty officer, aircraft fitter.
Yes, Lordship.
Next, R6.
My lord.
Is what?
He's a sergeant, your lordship.
Sergeant.
My lord.
Sergeant means Air Force.
Yes, lordship.
And what is his date of discharge?
30th June 2020, lordship.
Respondent 7. He's also Air Force or what?
Yes, lordship.
Air Force.
Yes, my lord.
And retirement?
30th June 2020, lordship.
Rank?
Rank is lordship, it's written as sergeant
Sorry,
clerk EA.
Sergeant Clark.
Clerk EA, my lord. In some documents, it's also shown as a corporal,
Or
but he was promoted to the rank of sergeant. Sergeant acting, my lord.
what about respondent 8?
Respondent number 8, my lord.
He is Havildar. Right?
Yes, lord. Yes, your lordship.
He is also clerk.
Yes, my lord.
Right?
Yes, my lord.
His
Havildar
date
clerk.
of discharge?
30th April 2019.
So against Mr. Respondent number 8, what is your check?
Your Lordship is a storekeeper.
He is
And-
also clerk. See the
No,
document.
Your Lordship, but these are two different, that is what I've been
Oh,
instructed,
not
Your
that one.
Lordship.
We are not here. We don't sit in appeal. He is storekeeper. He is clerk. See the document.
Because they're given the two different.
See the
charges.
document of the authorities. CLK,
My lord.
respondent number 8,
Yes, sir.
Havildar, clerk,
Yes, lordship.
date of discharge 34/2009,
Yes, my lord.
storekeeper also.
Lordship.
Then come to respondent number
9.
9. See the first page.
My lord.
To what post he had applied?
Has applied for welfare organizer. Lordship.
Here. Next. Respondent number 10. He is clerk,
Yes, lordship.
but he is not Havildar. He is Nayak.
MSCP Havildar.
MSCP Havildar, but he is Nayak.
Yes, lordship.
Then respondent number 11, no doubt, not an ex-serviceman.
Yes, she's a dependent.
Maybe she is a veteran of a Kargil martyr. But that we see that. And respondent number 12, there is no challenge because none of
13
the
also no
petitioners,
challenge.
none of the petitioners
My lord.
has applied for welfare officer. Respondent number 12 is out of the purview.
13 also. my lord.
Similarly, 13.
Yes, lordship.
Right? Their application is clear. They have applied only for welfare officer, organizer, and they have been appointed for the same post.
Right.
And there is no applicant from the petitioner side for the post of welfare officer.
Correct.
So 12 and 13 is out of your challenge. Then respondent number 14.
My lord.
36, 2020,
Yes, Lord.
date of discharge.
Yes, Lord.
Now facts are clear.
My lord.
Now your submission. The facts are, everybody is clear about the facts.
Yes, Lord.
Yes.
All right, your lordship. Now, as far as the date of discharge that is under contention here is, my lord, I have also annexed some documents and by learned friend for the state respondents.
Explanation.
Yes, some documents have already been placed before your lordship. My lord is fully aware now. The-
Regarding explanation, right?
Yes. So, your lordship,
Is there, I'm asking a query to everyone. Is there any statutory rules governing the matter of appointment? Any statutory rules governing the matter of appointment?
generally, yes, there is.
Which
No,
one?
no, for
Which one? Which one?
regarding the army,
See, if there is a rules
my lord.
and there is an advertisement, if the advertisement is conflict with the rules, the rule will prevail. Right?
My lord.
In the absence of rule, the advertisement will prevail. So anybody has referred to any rules?
No, your lordship.
So that is also it is admitted at the bar that there is no statutory rules governing the matter of appointment to the post in district signing. So that is also true. Now make your submission.
Oh, my lord,
You have to make submissions fourfold. One is regarding you.
The
As per
date of
number 12
return.
and 13, they are out. They applied for welfare officer. They were appointed as a welfare officer. None of the petitioners had applied for a post of welfare officer, so they cannot maintain a challenge. This is my view, subject to what the petitioner says.
my lord.
Next is response number 11. He is only a dependent of an ex-serviceman, martyred serviceman. So whether he comes within the category of ex-serviceman, this has to be answered by MS Supri and as MS Mr. Siki. Tell me.
Oh, first, on the point of the date of retirement, your lordship. Oh, my lord,
No,
usually,
we are coming to that. That is debatable.
No.
We are coming to that. I am asking about response number 11.
11,
He is a dependent of a martyr.
my lord.
Now, whether he falls in the category of ex-serviceman,
Your lordship, no.
MS Supri,
But how did the authorities have considered her appointment? They may have some policy or official instruction because your lordship, a martyr.
that is
can
why I
have
have
two dependents,
asked
your lordship.
specifically that whether any statutory rules are there. Because it is clearly meant for ex-service. That's all. Then you can now make your submission as regards date of discharge.
Date of discharge. My lord, I have also annexed some documents here.
Yes,
Along
yes.
with the writ petition which my lord, the affidavit in opposition, my lord.
That your notification, right?
Yes, my lord.
I think that is in page
Annexure 13, page 38.
30. Yes.
Now, my lord, the relevant portion at page 42 is a reproduction of the document which my learned friend has shown yesterday, but if I may be allowed to read, my lord.
Sure.
Explanation. The person serving in the armed forces of the Union.
Read the full.
My lord.
Why explanation?
All right, your lordship.
It is better to understand.
My lord. May I start reading from page 41? the
Yes, yes,
notification.
right. Yes,
Government of
yesterday
India
MS
Ministry of Personnel, PG and Pensions.
Just a minute. Yesterday, MS Supri has handed over a document. Page 38.
Here's an official notification now.
Yes, page 41.
My lord. The Ministry of Personal PG Pensions, Department of Personnel and Training, New Delhi, 27 October 1986. Notification, GSR, in exercise of the powers conferred by the proviso to Article 309 of the Constitution, the President hereby makes the following rules further to amend the ex-service Re-employment and Central Services and Post Rules 1979. Namely, these rules may be called the ex-serviceman Re-employment in Civil Services and Post Amendment Rules 1986. 2, they shall come into force on the date of their publication in the official gazette. 2, in sub-rule 2, in rule 2 of the ex-serviceman Re-employment in Central Services and Post Rules 1979, for clause C, the following clause shall be substituted, namely C. Ex-serviceman means a person who has served in any rank, whether as a combatant or as a non-combatant in the regular army, navy, and air force of the Indian Union, but does not include a person who has served in a defense security corps, the General Reserve Engineering Force, the Lok Sahayak Sena, and the paramilitary forces. And Roman 1, who has retired from such service after earning his or her pension, or 2, who has been released from such service on medical grounds attributable to military service or circumstances beyond his control and awarded medical or other disability pension, or 3, who has been released otherwise than on own request from such service as a result of reduction in establishment, or 4, who has been released from such service after completing the specific period of engagement otherwise than at his own request or by way of dismissal or discharge on account of misconduct or inefficiency, and has been given a gratuity and includes personnel or territory of the Territorial Army of the following categories, namely, Roman 1, pension holders for continuous embodied service, 2, persons with disability attributable to military service, and 3, gallantry award winners. Explanation. The persons serving in the armed forces of the Union who on retirement from service would come under the category of ex-servicemen may be permitted to apply for re-employment 1 year before the completion of the specified term of engagement and avail themselves of all the concessions available to ex-servicemen, but shall not be permitted to leave the uniform until they complete the specified term of engagement in the armed forces of the Union. The principal rules are published under white notification such and such, dated the 29th December 1979 in the Gazette of India, Part 2, Section 3, Subsection 1 at pages 3004 to 3005. Lordship, this, my lord will appreciate that this is a rule, and the rule itself permits them to apply for a job a year ahead, their retirement, of their retirement. And here there is a condition, my lord. For the Indian Army and Indian Navy, their period of engagement of within 15 years, after serving 15 years, prior to 15 years, if they wish to discontinue with their service, then they have to apply a year ahead, expressing the desire not to continue. In the case of the Indian Air Force, 20 years. So prior to 20 years, if they do not wish to continue, they submit an application a year or two beforehand, your lordship. And since the same was not annexed, not expecting that this would also become a question, my lord, I have 1 or 2 documents for your lordship's reference, if I may be allowed to place before your lordship. Yes, interesting. This is the one my lord is having a look is, at is the R7, my lord. Then I have also sent for R4, your lordship. This is how they apply beforehand. For R7, my lord may come to the last page, serial number 2. Lordship, that is the name of the respondent number 7. Akam Tiba Pongner, clerk EA.
Wait, come to the,
Last page, your lordship, serial number 2.
okay.
So it has already been approved by 3rd May 2019, my lord.
What is AFR2?
No, that I'm not aware. But this is how they apply beforehand. They can, if they wish to continue, my lord, beyond 20 years, that is regarding the Indian Air Force, then they can express their desire to continue further, my lord. Your lordship may also show your lordship for respondent number 4.
One,
Respondent number 4.
here, I'm looking at respondent number 2.
My lord, my lord.
Yes, respondent number 4 now.
Yes, my lord. My lord, this is discharge air warriors. I have made a type copy also as my lord's Senate. Discharge order in respect of the above named air warrior of this unit has been received from AFRO, white letter number so and so, 3rd May 2019. So and so, an air warrior will be discharged from service with effect on 30 June 2020 as per. So this is how they apply ahead of time on it. Then there is another document also for respondent number 4.
Yes. Unwillingness.
Yes, Lordship, their unwillingness to continue. Once they apply this, my lord, then may I take a lordship to page 19 of my affidavit in opposition.
Page,
19, my lord. This is pertaining to respondent number 4, annexure 2, page 19 of my affidavit in opposition. The NOC. No objection certificate. May I read, my lord? No,
this is
objection.
respond number,
4, my lord. No objection certificate. 1, service number such and such, rank, sergeant, initials and name in Awasami. Trade clerk PA was enrolled in the Indian Air Force on 22nd June 2000 and his scheduled discharge on expiry of initial RE extended is 30th June 2020. He is permitted to register his name with Employment Exchange to appear in any competitive exam and to apply for any civil post in central state government organization, paramilitary forces and public sector undertaking, including private sector. Number 3, this is very important, my lord. Point number 3. He shall be eligible for discharge from service on selection to civil post during the intervening period from date of issue of NOC to date of scheduled discharge on submission of appointment letter from the employer, subject to no disciplinary case pending against him. So even before they are released from service, my lord, they can be selected into service, and then they have to produce the same appointment order before the authority. So as per the rules that I have referred and the language in the NOC, which is similar with the other respondents also, my lord, as far as the date 30th June 2020 is concerned, it should not be an obstruction or affect the rights of the respondents number 4, 6, 7, and 14. My lord.
let's see, 7. Which is the document pertaining to 7.
Yeah, your lordship. Is 32 minutes. My lord. My lord, may also like to have a look at respondent number 6 also, because 30th June 2020, their also issue has been raised. Or if that,
Come to page to say 20,
21.
no, not 21. Is 27.
27.
This is respondent number 6.
6, my lord.
Now, what is this book? Service book.
Yes, lordship.
Service book.
The date of discharge is
This
30th
was
June 2020.
30th June 2020.
My lord.
Now, let us flip through, then come to say page 32. Okay, 32 we have seen. Then your notifications
Good.
with explanation. Then see page 47.
My lord. My lord.
What does it say? Discharge book.
Yes, lordship.
In respect of Indian Air Force, it is
This is IMLA
service
Counsel.
book.
Yes, lordship.
Indian Air Force, it is service book. In case of
Indian
Army,
This is
it is
discharge book.
discharge book.
My lord.
Then where is the next man? Page 50.
My lord.
Discharge book. Question number 9.
Yes, lordship. Then page 54, lordship, Indian Army, so it's known as
54.
discharge book. My lord.
Discharge book. Yes, discharge. Page 81. Discharge. Now, let us go back to the advertisement.
81, my lord,
Recharge book,
it's service book, my lord, 81. This
81.
is Indian Air Force. It's
So
81,
there is service book.
service book, my lord.
So service book. Now come to the advertisement.
Yes, my
89. 89.
89, my lord.
What does it want? How to apply? Clause 6
Yes. Simple application and
C.
plain paper.
C.
Photocopy of release, discharge.
Certificate
book,
stroke book.
my lord. My lord.
This can be only available when a person is discharged.
Your lordship, it is made available to them before their actual discharge, my lord.
Discharge book bearing 30 June 2020.
That I have to inquire, my lord, because, yes,
If you want to take the risk, you take the risk at the cost of 1 lakh.
your lordship.
Have you understood?
No, I got what your lordship has said. But
A
usually.
discharge
Yes,
book
lordship.
with a subscription of a date 36/2020
My lord.
by an Indian Army, Indian Navy, or Indian Air Force
Yes.
cannot be issued prior to that date.
Or in your lordship's word, could not have been submitted to the office prior to
Absolutely,
21st
there
March.
is no doubt
2020.
about it.
Yes, lord.
There is no doubt about it.
My lord.
Indian Army will not issue, Indian Navy will not issue, Indian Navy will not issue any discharge certificate prior to the date of discharge. Yes, he is eligible to be discharged. Okay. But within 1 year, many things can happen. See your document. I have seen. See your document in which you have handed over loose papers.
My lord. For,
Loose papers you have given to me.
yes, my lord.
This one.
For
Clause
respondent
4. Airmen are to report to this office on attachment for final clearance on the date as shown against their name. Please ensure reporting for final clearance at this office is a mandatory requirement. So this is provisional that yes, you are eligible to be discharged on so and so date. That is advance notice. Ultimately, the final clearance, many misconduct may happen within 1 year. Anything more?
Your lordship, in respect of the rank, more particularly the respondent number 10.
Show me that by MSCB, Havildar,
My lord.
he can attain the substantive rank of. Show me the MSCB scheme.
No, your lordship, that I have asked last night also, but I could not get the document, so I'm not competent enough to. Lordship, I was asking for that last night, so
It is
that I will be
available.
able to.
ACP scheme is of 1999. MSCP scheme is ACP is Modified Career Progression Scheme.
No.
When MSCP was introduced in 1999, there were two financial upgradations. That is called financial upgradation.
No.
If suppose the service condition is that 5 years minimum experience in the feeder post is necessary. In the higher post, there are suppose 10, but experience are 200. only 10 will be promoted on the basis of seniority come merit or merit come seniority, whatever. Rest 190 will be left in the large. So since they have devised a program that after 12 years, if they do not get the first promotion, they will be given the financial benefits of the next higher post. But their rank will be of the feeder post because one can be promoted only if there is vacancy. There is no vacancy. So they will be given the financial upgradation to the next higher post. They do not get substantive promotion. With the promotion, two things. One, he enjoyed the status with higher responsibilities. The second is financial benefit. By the SCP scheme, only the financing. If I am wrong, MS Supreme, SCP and MSCP. SCP was 12 years, first financial upgradation. If there is no promotion, next upgradation is 24 years. SCP. Then MSCP was introduced. I think in Nagaland also perhaps introduced. First financial upgradation at the end of 10 years. Second upgradation in the end of 20 years. Third financial upgradation at the end of 30 years. People may retire by staying in the same post, but they will enjoy the benefit of the higher post. Financial benefit.
Lordship.
Not
In terms of military service, 8 years now.
everybody has introduced thereafter.
Yes, Lord.
So this is what the post is. This is a difficulty.
So in respect of the respondent number 10, my lord, in fact, I was trying to get some documents so that I will be able to assist your lordship.
He is MSCP Havildar.
Yes, lordship.
His substantive rank is Nayak. And as per your document, page 97,
My lord.
he is not, he is below Havildar,
Yes, lordship.
your document. Right?
No.
That is go. Now, respondent number 9.
Yes,
Though he is of JCP rank,
yes, lordship. Now here, my lord, I have an authority to place before your lordship.
yes,
The case of the administration of Chandigarh versus Jasmine Kaur. Lordship, he has been appointed to the same rank, same pay level, though he has not applied for it. Now, it is the action of the authorities. So respectfully, my lord, the action of the authorities should not have an adverse effect on the respondent number 9. And for this, I'm playing this authority, the Chandigarh administration another versus Jasmine Kaur another 2014 10 SEC.
but who challenged his appointment?
My lord.
Who challenged his appointment there?
No, this is to do with admission, my lord. But where the fault cannot be attributable to the,
His, definitely, respondent number 9
yes, lord.
was not at his fault. He
No, sir.
applied for welfare organizer.
My lord.
He was clear in his mind. And authority decided to bestow benefit, unexpected benefit on him.
And
Right.
yes, lord.
Authority decided. They have provided the explanation in paragraph so and so of their affidavit. Right.
Yes, lord.
Now, the question is here, that action has been challenged by a deprived candidate. Now, what is the fact there? Chandigarh.
My lord, before reading this judgment, I may be allowed to produce the convening order where it says that the interview board, they have the discretion. May I please be allowed to read, my lord? This is issued by the government of Nagaland, the Home Department. May I read, my lord? More particularly, the second last paragraph and the last paragraph, The board may also examine the desirability of relaxation of guidelines if necessary, and give recommendations to
Which
deserving
page,
candidates.
which page?
The first page, my lord.
Okay, first page.
Yes, Lord.
In pursuance of the government of Nagaland.
Type copy is on the next page, my lord.
I read the original.
My lord. Even noted dated 22nd November 2021 and consequent to advertisement number so and so dated 12 February 2020 issued by the Home Department, Police B Branch, Government of Nagaland for re-employment against post of Directorate of Sainik Welfare and Resettlement Nagaland and in Zilla Sainik Welfare Offices. The Governor of Nagaland is pleased to convene the meeting of Selection Board for the Directorate of Sainik Welfare and Resettlement Nagaland in the Conference Hall of the Chief Secretary, Nagaland, 11 a.m. on 13, 14, and 15 December 2021, consisting of the following members. Chairman, Chief Secretary to the Government of Nagaland, 2. Principal Secretary, Home, Government of Nagaland, Principal Secretary, Law, Principal Secretary, PNR, Special Secretary, Home, Representative of Ex-Servicemen Welfare Department, Secretary, Representative of Kendriya Sainik Board, Member Secretary, Director, Sainik Welfare and Resettlement of Nagaland on his representative. The selection board will examine the eligibility and suitability of the impaneled candidates with reference to the eligibility criteria prescribed by the Department of Ex-Servicemen Welfare, GOI MOD in New Delhi for appointment of officials in the Directorate of Sainik Welfare and Resettlement Nagaland and as incorporated in the Directorate notification number so and so, 29 February 2016. And the last part, which I beg your lordship to frankly.
I have read.
Yes, lordship.
I have read.
Relaxation of guidelines if necessary. So perhaps.
Yesterday I said
My lord.
one word. Rules of the game.
My lord.
This is not a notified order. Rules of the game have been changed after the game has started, which is not permissible at any cost. You have changed the rule of the state despite this convening order. This board may also examine the desirability of relaxation of guidelines if necessary and give recommendation to deserving candidate. Rules of the game have been changed in a midstream.
Lordship, may I take a lordship to paragraph 32.2 of the judgment.
Thirty-two.
32.2. May I read, my lord?
33.2.
33.2, my apologies, Your lordship, 33.2. Under exceptional circumstances, if the court finds that there is no fault attributable to the candidate, that is, the candidate has pursued his or her legal right expeditiously without any delay, and that there is no fault, there is fault only on the part of the authorities, or there is an apparent breach of rules and regulations, as well as related principles in the process of grant of admission which would violate the right to equality and equal treatment to the competing candidates, and the relief of submission can be directed within the time schedule prescribed. It would be completely just and fair to provide exceptional reliefs to the candidate under such circumstance alone.
Now, what is the case of that? Facts.
So, Your Lordship, this case is about
Fact.
admission to the institution, my lord. The facts of the
What
case
is the fact? The court making
admission to dental college, my lord.
was the case here.
My lord.
Some NRI category post. Admission. Under what situations he was given admission in dental, BDS?
Your lordship, paragraph 3,
Let's read paragraph 3.
the contesting respondent claimed that her grandfather retired as an under secretary in the year 1994. When he was in service of the state of Chandigarh, he resided in a government house from 1965 to 1984 and shifted to another government accommodation provided by the Chandigarh administration from 1984 to 1994. Third set of government accommodation was provided by government to the father of the contesting respondent. It was occupied till December 2003, and thereafter the father started living in the house of her grandfather in Mohali. The contesting respondent claimed that she passed as a regular student from Mohali, that a prescription contained in para 2 of the prospectus providing for eligibility and merit for NRI seats for MBBS course stipulating that the parents of the candidate should be resident of Chandigarh for a minimum period of 5 years and at any time since the origin of Chandigarh and should have immovable property in his or her name in Chandigarh for at least 5 years, and a certificate to this effect issued by the DC cum estate officer of or municipal corporation in Chandigarh was not valid. Your lordship, here,
It was that Chandigarh administration versus Jasmine Kaur.
yes, lordship,
And it was Jasmine Kaur who instituted the writ
yes.
against the government.
Yes, lordship. But before the Honorable Supreme Court,
Then
She was
Supreme
a
Court did
respondent.
what? Division bench did what? Put her in BDS course.
yes, your lordship,
Then paragraph 32.2.
my lord. But it was found that your lordship, the fault could not be attributed to her. And hence the Honorable Supreme Court expressed the opinion that when the fault is not attributable to the candidate, the court looking into the issue should mold an exceptional relief in favor of the candidate. And if that same principle is to apply, my lord, respectfully, your lordship,
But here is a challenge mounted by other candidates. That is a difference.
yes, your lordship, to that extent, I cannot disagree with your lordship, but I understand, my lord. But the question is whether,
Because there the contesting respondent filed a petition challenging a clause that this is completely arbitrary. And it should be set aside. And that in such situation, some years gone by, court directed admission to her because she was pursuing her legal remedy without any delay.
yes, your lordship,
But
respectfully,
here
my
is the
lord,
case.
if it is to be applied the other way around, whether victimizing at all, the decision goes against the respondent number 9. Okay. 9. Then your lordship, the negative impact,
The best benefit has been bestowed upon the respondent number 9 by the state. Admittedly,
yes, your lordship,
going by the application, by changing the rule of the game, by this convening order, which was never published by any corrigendum, addendum to a selection process. The game has started. Last date was 31/3/2020. And this order has come about on November 2021. 1.5 years game is on. Game started with the last date, all applications filed 31/3/2020. Game has started with a rule incorporated in the advertisement, how the game is to be played. Then selection board also cannot go beyond the advertisement. That is the
Lordship,
question I asked at the very beginning to all of you, whether any statutory rules were there.
can my
No.
lord also see from this angle?
Except Mr.
Yes, lordship.
Sheki,
My lord.
subject to what you say more. Respondent number 8. Okay. He is Havildar, he is clerk. His date of discharge, 34/2019. Respondent number 12 and respondent number 13. They are okay. They
Are okay.
cannot, they are okay. But so far as others are concerned, this man has been given undue benefit. R9. That's not what I. He did not ask for it. Though advertisement were so many posts, you were eligible for so many posts, but he decided to opt for only one welfare organization.
Can my lord also view from this point, whether the advertisement says that you cannot appoint a person eligible, not applying for a particular post?
No,
Whether the
when
advertisement
he
is
has
silent
not
on
been
that point.
asked for it, why it is ordered then? Convening order. What is the necessity then of issuing such kind of order? To give impetus to illegality.
This one is not under challenge before this court.
Not required, because this is not non-esteem law. And you have gamed the play, you have changed the rule of the game silently and surreptitiously. Is there any publication of this? No.
Even otherwise, my
No
lord,
gazette notification, no publication.
leaving
nothing.
aside the document, my lord. If,
Every document is pointed
Lord.
against you.
lordship, even assuming, if my lord may kindly allow me to make this assumption, even assuming that that notification is silent,
Which one?
that the document, the convening,
R9.
the convening order, yes, lordship. Now, even that is silent in respect to R9, my lord. The advertisement is silent about that until and unless you apply for this particular post, then he cannot be appointed for other posts. In fact,
Then
in respect to
put
that
an
point,
application, put an application. One uniform application, generally application, that application will be everywhere applicable then. Everywhere applicable, wherever grade 4 vacancy is available, all over the Nagaland.
Lordship,
And one can bring that application, put it here, one can bring in that application. There has to be certainty, non-discrimination, transparency in recruitment process. But here, you have made the application for welfare organization. At that time, you decided not to work in any other post but welfare organization. But otherwise, you are eligible for
no,
many,
yes,
but you opted for only one. You were pretty sure about it. But respondent number 12 and respondent number 13, they got selected. So what to do with you? You are perhaps the blue-eyed boy. Convening order. Yes. Anything more? We'll resume after 5 minutes.
no,
Give me 5 minutes.
lordship.
Any other authority, Mr. Supreme?
Yes, lordship,
Supreme Court? Or High Court?
some apex court decisions, my lord, that after they have already participated in the selection process and have come out unsuccessful, have turned around to challenge the same process. My apologies, Your Lordship.
No, it's okay.
No, my lord,
Hmm,
I just met an inquiry
hmm,
pertaining to the advertisement,
hmm.
which my lord was pointing out earlier. Now the advertisement at page 59.
89.
Lordship, my lord was pointing out the clause 6, subclause C,
See.
photocopy of release/discharge certificate and book. Your Lordship, here it is fairly admitted that the private respondent number 4, 6, 7, and 14, they did not include this at the time of submitting their application. Now, my lord, here, my lord may kindly consider this point, whether this advertisement can sit over the notification of the rules that I have placed before your lordship under 309 that has permitted the employees who are about to retire prior to the year of retirement to be able to apply. So if that principle is to be considered by this honorable court, then my lord, it should not serve as an obstruction for them to apply for the post. That is my submission on that point, my lord. Now, my lord, I may be allowed to please two authorities. The 2017 9 SCC 478.
Yes.
Lordship, I'm relying on paragraph 4, 8, and 10. May I be allowed to read them? Short paragraphs. The main ground urged on
Paragraph?
paragraph 4, formal.
Hmm.
The main ground urged on behalf of the appellant is that respondent number 1, have taken part in the selection process, could not be permitted to challenge the same after she was unsuccessful in getting selected. The law is well settled that once a person takes part in the process of selection and is not found fit for appointment, the said person is stopped from challenging the process of selection. Then the paragraph 8, my lord. In Ramesh Chandra Shah versus Anil Joshi, the petitioners took part in the process of selection made under the general rules. Having appeared in the interview and not being successful, they challenged the method of recruitment itself. They were not permitted to raise such an objection. This court held as follows. In view of the proposition laid down in the above noted judgments, it must be held that by having taken part in the process of selection with full knowledge that the recruitment was being made under the general rules, the respondents had waived the right to question the advertisement or methodology adopted by the board for making selection, and the learned single judge in the division bench of the High Court committed grave error by entertaining the grievance made by the respondents. And my lord, the paragraph 10. The Kerala High Court did not note the above mentioned judgments and ignored a well-settled position of law in rejecting the specific plea raised by the appellant, hearing that the appellant could not raise the issue that no direct recruitment would have been conducted once she had applied for and taken part in the selection process by direct recruitment. My lord, 2014-16 SCC. Paragraph 16 SCC 187, my lord. Ranjan Kumar and others versus State of Bihar and others. Lord, I'm relying on paragraph 14 to 17. Short paragraphs, my lord. May I read, my lord? The next submission which has been presented before us is that when the respondents had appeared in the interview knowing fully well the process, they could not have resiled later on or taken a somersault, saying that the procedure as adopted by the department was vitiated. In this connection, it is apt to refer to the principles stated in Om Prakash Shukla versus Akhilesh Kumar Shukla. In the said case, a 3-judge bench taking note of the fact that the petitioner in the writ petition had appeared for the examination without protest. He filed a petition only after he realized that he would not succeed in the examination. Held that the writ petitioner should not have been granted any relief by the High Court. In this context, we may quote passage from Madan Lal versus State of J&K, paragraph 9. It is now well settled that if a candidate takes a calculated chance in appearing in the interview, then only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or the selection committee was not properly constituted. In Om Prakash Shukla versus Akhilesh Kumar Shukla, it has been clearly laid down by a bench of 3 learned judges of this court that when the petitioner appeared at the examination without protest, when he found out that he would not succeed in examination, he filed a petition challenging the same examination. The High Court should not have granted any relief to such a petition. In Chandra Prakash Tiwari versus Shukantala Shukla, the court observed as follows in para 34. There is thus no doubt that one question of any estoppel by conduct would not arise in the contextual facts, but the law seems to be well settled in the event of a candidate appears in the interview and participates therein, only because the result of the interview is not palatable to him. He cannot turn around and subsequently contend that the process of interview was unfair or there was some lacuna in the process. Para 17. In the Union of India versus Vinod Kumar, the court reiterated the principle that it is also well settled that those candidates who had taken part in the selection process, knowing fully well the procedure laid down therein, were not entitled to question the same. My Lord, to conclude my submission, Lord, in respect of the respondent 9, 10, and 11, in respect to the respondent number 9, yes, as my Lord has pointed out, he applied for welfare officer, but it was the authorities who appointed him to the post of UTA, which is also in the same pay scale, Your Lordship, pay level 7. However, for the action which the respondent number 9 cannot be held responsible. Anyway, my Lord, it is my humble submission that may kindly be reported that he should not be victimized. In respect to respondent number 10, my Lord, yes, he is MSCP Havildar. So I do not know to what extent the recruitment policy accommodates a person who has enjoyed that pay scale to be given that benefit. To that extent, Your Lordship, my apologies that I could not assist Your Lordship to your satisfaction. Now, coming to respondent number 11.
Sir, I got the MSB scheme
My Lord,
in the meantime to the office
Lordship. Now, in respect of the respondent number 11.
for your information.
My Lord.
MSCB says financial arbitration will be available in a next higher grade pay whenever an employee has completed a stipulated continuous years of service. But to be promoted substantially, he has to go through the selection process, fulfill all the criteria. Right? This is the process under the MSCB. Only the money, extra money is given. Financial upgrade. So he remains in the substantive rank, but enjoys the pay scale of the higher post. After 12 years or 10 years, whatever the scheme is, he gets the benefit. This is the law.
Your Lordship, and in respect of the respondent number 11, Lord, as far as the advertisement goes, my Lord is correct in pointing out that yes, it is specifically for ex-servicemen. Our Lordship, given the fact that the the respondent number 11's brother has also sacrificed for the county. There's
I
some
have,
consideration.
but when it comes to a recruitment process, sympathy does
My
not have
lord,
any
my
place.
Your lordship. Lordship.
Though court has a sympathy, but court has to apply the law, rule of law has to prevail. And if in a case of compassionate appointment, yes, this is not a thing. It is not a case of compassionate appointment. These applicants, both the petitioner as well as the respondent, they are enjoying pensions. It is not a case that they are suffering from penury.
No,
They are
Yeah,
enjoying
lordship.
pensions,
My lord.
but since they are agile, physically fit, they can also be appointed.
My
Thus,
lordship.
this
My lord.
clause 3
Lordship.
of your advertisement, all posts are reserved for ex-service who come under the definition as given in the official position. That is that rule where the expression was provided. What ex-serviceman? It is loud and clear.
No, my lord.
I'll take note of your submission.
My lord. Respondent 5 and 8, there's no dispute. They are squarely qualified.
5.
And 8, my lord. Then
8 is okay. 8 is okay. 12, 13. Okay.
12, 13, okay, yes, lordship. And respondent number 4, 6, 7, and 14, my lord. 4, 6, 7, and 14, my lord.
Okay, we'll see.
Since the rule permits, it is my humble
Okay, we'll
submission that, yes, my lord.
Yes.
That's my humble submission, my lord.
That is at page 19 of the petition. The advertisement of February 2020, it invites application from the members of ex-servicemen or army and air force military. And in the third column, lordship, it says rank held in the army or equivalent rank in navy and air force. Lordship.
Which one?
In page 19, this is the type copy of the advertisement. In the last
Which clause? Which clause?
fifth column, Lordship.
Huh?
Fifth.
Clause 5.
Not clause 5, the lordship, the fifth column, the lordship, the top one is serial number, post.
Requisite rank, yes.
Yes. So the last column says requisite rank held in the army or equivalent rank in navy and air force. Lordship. Then class 3 and class 4 no gazetted lordship. Number say all these posts requires JC or Havolda clerk. Lordship. So if you are that the petitioners are all Havolda clerk and the rest of the respondents are not Havolda clerk, then it's why they are not eligible to.
On that ground, they challenged,
Yes.
but ultimately, at least for respondent number 8, it turns out to be a Havildar clerk.
The lordship is the contention of the petitioner, then it applies the advertisement only for the army, because in the navy and the air force, they have different names of equivalent rank. So even as a Havolda in the army, the lordship.
I have seen, according to private respondents, they have given equivalence of ranks.
Yes.
Now tell me, according to you,
Yes.
if state comes out with equivalence of ranks, it is well and good.
Lordship.
From private respondent, page 97, they have given the equivalence of ranks. We are going for it.
Yes.
But if you have any other equivalence of ranks, show it to us.
That is the equivalent.
That is equivalence.
Yes, so the petitioner can state
Which one?
that the respondents are not Havolda clerk, so they would not to be appointed to lordship. Because the only condition is that the applicant should hold the post of Havolda clerk in lordship. That is the contention of the petitioner.
Hmm.
So the JCO, these are the Havildar, Subidar and below rank, Your Lordship. And the Havildar clerk, it comes under the NCO. Your Lordship.
See, there are two sergeants.
Yes.
Two sergeants. They are from Indian Air Force.
Mm.
We are not required to go into that
Yes.
because their discharge certificate is of date 36/2000.
But Your Lordship, the discharge certificate Army, which provides that an ex-serviceman, the definition of ex-serviceman, and a person who is about to retire prior to 1 year, he can apply for civil post. Your Lordship.
May be permitted.
Mm.
See that.
So the,
See the explanation.
may be permitted to apply.
Maybe that is not, it is not shall. And you have laid down the law, rule. You have yourself laid down the rule. Come to clause 6. C.
Yes.
Now you want to deviate from that.
Yes, photocopy of release discharge certificate book. So accordingly, the Army, the Navy, and the
Law is settled. The eligibility of a candidate is to be decided on the last date of application, if no rule is governing the field.
but the meaning, the definition of.
Okay, that is your explanation. We'll record it.
Yes, the definition of.
Okay, we'll record it.
And then, Your Lordship, there was an eligibility and suitability test, Your Lordship. So the petitioner, they failed in the interview, Your Lordship. And now after failing the exam, they are approaching this court, challenging the actions of the government. Your Lordship.
Where did you say? Where did you say they have failed?
Lordship,
Where did you say they have failed?
but I said it, Your Lordship, that it's 7 para 6.
Yeah.
Page 7 para 16. That is regard to the petitioner had also applied to the and everyone was provided equal opportunity. The final selection for appointment was done solely on the.
Is there any cutoff mark? Is there any cutoff mark?
Lordship, regarding with that. But surely there would be, Your Lordship, without the cutoff mark, how could that person be?
No, if
Depending on the number.
if the number, yes, there could be different situation.
Yes, yes.
That 5 posts, top 5 will get.
Yes, so the highest mark of the person.
Respect of say NPSC examination or written examination, first screening
Yes,
is done. Suppose only a person gets 50 marks, he will be eligible for main examination or written examination. Here it is only interview.
yes.
Here it is only interview, right?
Depending
If
on the marks, there's
maybe the top 5 will get, top 6 will get, there may not be cutoff mark.
no. Yes, yes.
This is the situation, this could be a different situation.
Yes, Lordship. So the final selection for certain of the
And as per the marks obtained, where did you say they have failed?
There were no
See,
selections, so
see,
there-
everything has a bearing. And it will be a supposed written examination. 50 is the cutoff. Only those candidates who have obtained 50 marks, they will be permitted to appear in the interview. It is not such a thing. It is, say, 5 posts. All are suppose held to be qualified, eligible. Now, here is a question. All these judgments they have said, so many judgments. There, the persons who were appointed, they were eligible in terms of the advertisement, right? petitioners were also eligible. But since the petitioner were below, they cannot, after appearing in the interview, they are stopped from challenging. Here is a question, they have raised the question of eligibility of the candidates appointed. This is the fine distinction. Mr. Seki has given 3-4 judgments. All these are not on the point that the appointed candidates were ineligible. Both were eligible, but they were behind the who challenged, they were below the merit list. Top candidates were appointed. That is the law. Then they are stopped from challenging. But here is a question, they raise the eligibility of the appointment.
So your worship, who can decide whether a person has the eligibility or not?
Here it
the
is.
state. Who has to decide? your
This
worship?
has to be decided on the basis of the advertisement
So the
and the explanation you have shown.
So the
We'll
advertisement-
decide. We have been asked to decide.
So the advertisement is that it should be an advertisement. So all these respondents about only the specific that comes between the.
Okay.
The entire process of recruitment was conducted in an impartial manner. Therefore, when the petitioner then you will also come to read my page 6 in my paragraph also.
Here,
Paragraph, page 6. After the statement make a paragraph heading of the petition are denied. The army and the economic strength in the navy and air force required for the post of class 3 and class 4 non-gazette. In the it is JCO about the clerk and NCO clerk. However, the petitioner was true that the requisite criteria is appointed clerk only. The respondent impressions are either JCO about the clerk, NCO clerk in the equivalent role, having the corresponding qualification for the same post. As such, the selection process will suffer from arbitrary and.
no, yes, agree. So far as respondent number 4, respondent number 6,
Yes.
respondent number 7, 40. This respondent number 4, 5, 4, 6, and 7. I don't know about respondent number 8. What was his? He was in army or navy? Army. Huh? Respondent number 14. Sergeant. Yes. Had this been the question whether sergeant
Yes.
is equivalent
Yes.
to Havaldar
Yes.
clerk, that would have been a debatable question which court will find, would have found difficulty. Right. There is a question that is not required to be gone into.
Yes.
So why should I go?
Yes. Yes. So your lordship,
We will go only by the advertisement and the explanation you have given.
Lordship.
So I have thought it over. We do not require to go into the whether
Yes.
sergeant in Indian Air Force is equivalent to
About that.
Havaldar clerk. We do not have to go into that.
Exactly. And for the
We can decide on the basis of
exactly. And
not required for at least for respondent number 4, 6, 7, and 40.
so it's the regulations of
The rest of other 11, 12, 13, it is already clear. Respondent number 8 to the considered view of the court, at least his date of discharge is prior to that. He is Havildar, he is clerk. At least his document it was CLK or clerk, it was written. That is also clear.
My humble submission is that we have conducted the selection process in the.
This convening order is
No,
Melabai.
that one which Madam is stating about the direction of the legislative board.
Hmm?
The direction, yes.
These are all extraneous document for the court also. You have not brought anything.
Yes. My submission is that every petition, the law has to go for it. That's right.
Okay. Yes. Anything?
I'll only take 5 minutes.
Hmm?
Some clarification has to be done.
Hmm.
As far as respondent A is concerned, I leave it to the wisdom of this court for interpretation whether SPD comes under the trade of clerk or not.
His document shows at least Habildar.
Yes, Your Lordship.
He could be a storekeeper, but at the same time, he is also a clerk. Document shows you, for your satisfaction, you can see.
Eight, I'm not disputing that,
And
Your
his
Lordship.
date of discharge is prior to 31/3/2020. So when the prima facie it is, he is eligible, would not
that
like
extent, I
to
agree, Your Lordship.
make any interference. We do not know about respond number 5. Let us see once again. He is petty officer,
Technical trade, Your Lordship.
a technical aircraft fitter.
Yes, his past service was of technical in nature. And that the prerequisite in the advertisement is should be clerical in nature, Your Lordship. The qualification.
But whether he is JCO, JCO is in army.
Yes, Lordship, but that will be the
JCO
rank
is in army?
of NCO.
Huh?
Petty
Yes.
officer is in the rank of
No.
Havildar,
Whether this-
equivalent rank of Havildar.
No, whether this JCO, junior commission officer, this rank is only available in Indian Army.
No.
And without document, don't make submission.
Your Lordship,
To make document. No, internet, Google will not do. Get some notification.
Your Lordship, the JCOs are officers who were appointed through the Indian Military Academy and the officers.
So,
training academy.
Mr. Don't make here and there submission. This kind of submission will not do. Might be, maybe, should be, this will not do.
Lordship,
Otherwise, by equivalence, petty officer is equivalent to Havildar.
Havildar, yes, Your Lordship. Simple as that, my lord. Instead of going into NCO and JCO. NCOs are
Otherwise, as per
stripes.
this equivalent rank, because this is a part of a document. This document is issued. This document is by Officer of Principal Controller of Defense and Accounts. Okay. This shows clause 5.5, appendix Y. This is appendix Y.
Yes, my lord.
Petty officer is equivalent to Havildar. So without more, Mr. Counsel, without more cleansing document, how can I incite this? I do not sit in appeal. See, we do not sit in appeal. We see the decision-making process. The decision-making process here is that ineligible candidates, few ineligible candidates have been made apparently eligible. We can only deal on that. Respond number 5, we do not know. Petty officer is equivalent, shown to be equivalent as Havildar Dafadar. He is from Navy. We don't know what he do. Storekeeper, he can be clerk.
To that extent, I agree, historical, Your Lordship.
Palpably clear is all those. Response number 11. Response number 9. Respondent number 10. And respondent number 4, 6, 7, and 4. So far, 5, we cannot decide. Next, we cannot decide about respondent number 8 and plus respondent number 12 and 13.
Your Lordship, there's a judgment. What I would like to place. Similar to this, the respondents have been relying on the NOC provided by the employer.
Which one?
The NOC, there's a judgment. Even though they are in service with the NOC, they can apply for the examination. That is what they have contended, Your Lordship. I will be relying on paragraph 4. If Your Lordship allow, I will read.
Yes, yes. Respondent number? Paragraph?
Paragraph 4, Your Lordship. This is the factual matrix of the case. The appellants were serving armed forces in various capacities at the relevant time. When an advertisement was issued by the Uttar Pradesh Supplementary Service Selection Commission, wherein after referred to as the Commission, for recruitment to the post of Village Development Officer. The registration for application commenced on 18/1/2016, and the last date of submission of the application form was 10/2/2016. The applicants applied in the category of ex-servicemen after obtaining no objection certificates, wherein referred to as NOC from the employers. Initially, the result was withheld for various reasons, but ultimately they were issued appointment letters on 29/5/2019, appellant number 1 and 2, on 27/5/2019, and 3, respectively on temporary basis. Worthwhile to note is that this was after the appellants were asked to appear before the commission on 26/12/2018 with necessary documents pertaining to their qualifications and more so with regard having equivalence of to the course of computer concept, wherein referred to as the CCC certificate. However, short course notice was issued by the respondents number 3/district development officer, but down to the appellant number 1 and 2 on 19/2/2020, and to the appellant number 3 on 12/2/2020, as to why their appointment did not have to be nullity, as on the last date of submission of application form, they were employed with armed forces and could not be treated as ex-servicemen. And further, they did not possess the CCC certificate issued by the DOESC, now NIMIT. The contention will be at para 12, Your Lordship. Learned Counsel indicated that even in the NOC issued to the appellant number 1, it was mentioned that he was eligible to the civil appointment after the particular date specified, which was beyond the last date of submission of application forms. And further, the NOC also mentioned that the officer/employer had no objection to the registration of the appellant's name with the employment exchange, which in no way could confer on him a right to be considered under the category of ex-serviceman. Thus, the Learned Counsel contended that the appellants in any view of that matter would not have taken any civil employment unless they were actually relieved, superannuated, or retired, which ultimately would be the decision to be taken by the employer, and mere indication in the certificate ipso facto would not mean that on the date of indicated, they will automatically come within the category of ex-servicemen. The findings will be at paragraph 16, Your Lordship. Some objections were reiterated here. In Rakesh Sharma Supra, this court, after noticing inter alia Dr. M. Nair versus Union of India, 1993 to SSP 429, Uttar Pradesh Public Service Commission versus Afghana, 1994 to SSC 73, Upendra Singh versus State of Punjab, 2005, SSC 260, and State of Gujarat versus Arvind Kumar, T. Tiwari, 2012, and SSC 545, reiterated that the basic qualification is to be adjudged as on the last date of submission of application forms. Subject to any extension of such date by the concerned authority, In Rika Chaturvedi, Srimati versus University of Rajasthan, 1993, Secretary SEC 168. The court, though, opted not to disturb the appointments, therein on the ground that over 8 years of service have been put into the council appointees. The proposition was enunciated as under. The condition that the required qualification of candidates should be examined with reference to the date of selection and not with a reference to the last date of making application, has only to be stated to be rejected. The date of selection is invariably uncertain. In the absence of knowledge of such date, the candidates who apply for the post will be unable to state whether they are qualified for the post in question or not. If they are yet to be acquired the qualification, unless the advertisement mentions a fixed date with reference to which the qualifications are to be judged, whether the set date is of selection or otherwise, it will not be possible for the candidates who do not possess the requisite qualification in a presently even to make applications for the post. The uncertainty of the date may also lead to contrary consequence vis-a-vis even those candidates who do not have the qualification in presently are likely to acquire them at an uncertain future date may apply for the post, thus swelling the number of applications. But a still worse consequence may follow, in that it may leave open a scope of malpractices. The date of selection may be so fixed to manipulate as to entertain some applicants and reject others arbitrarily. Hence, in the absence of a fixed date indicated in the advertisement notification inviting applications with reference to which the requisite qualifications should be judged, the only certain date for the scrutiny of the qualification would be the last date of making the applications. Paragraph 17. The court writes this judgment instead of Bihar versus Mathuban Ranjan online 1262 also took the view that as per the settled proposition of law, a candidate slash applicant has to comply with all the conditions, eligibility criteria as per the advertisement for the cutoff date mentioned therein, unless extended by the recruiting authority. This also pertains to the ex-serviceman logic.
So there, Mr. Seki, they were appointed or not appointed?
No.
There is an interim order.
No, we have not been appointed, Your Lordship.
And Your Lordship, as far as respondent 19 is concerned, MSCP Your Lordship, mere granting of a salary does not treat them to be equal with a higher grader, Your Lordship. That's no is settled. So I did not argue much on that. With that, I conclude my submission.
Okay, now almost one will dictate at two. We'll dictate the order at two.
One clarification. In respect of respondent number respondent number 4, 6, 7, and 14, Your Lordship would put a query that the discharge was on 30/6/2020. Lordship, that is after the last stage for receiving of the application. But 30/6/2020 is the actual retirement date from regular engagement in the respective fields.
That has been dealt with by the Supreme Court judgment. Just now, ex-serviceman, which the petitioner has liked. That has been dealt. They'll further, if this condition of eligibility is not fixed on the last date of application, then there will be scope for manipulation. Ex-serviceman, special judgments.
Lordship, sorry for indulgence, Lordship. Item number 46, Lordship. This matter was heard yesterday. Item 46. From the supplementary, Lordship. Supplementary, Lordship.
Yes, yes.
Hearing item number 46, Lordship.
Yes, we heard it
Yes, Lordship.
some length.
Yes, since the matter might not reach Lordship, so if we come up on Thursday, as a item, Lordship, on Thursday.
Thursday.
Yes, Lordship. I've taken the concern of the petitioners.
Leave the case. As for Mr.
I intend for the petition.
And Mr. M. Mojui, Counsel for Responsible Entry, leave the case on Thursday.
Lordship is an interim that may be completed.
In favor of consideration.
Obliged, Lord.
Yes, Lordship.
Yes,
Lordship, kindly allow me to mention item number 43.
43.
Yes, Lordship.
Yes,
Lordship, kindly listen after it.
on the prayer of Mr.
Mr. Kajish, Lordship, for respondent number 1, 2, and 6.
Okay, Nishuka CC.
Yes, Lordship.
Counsel for Responsible number 1, 2, and 6.
Yes, Lordship.
Use the case after week. Because we submitted. Which one to make the fair?
Yes, Lordship.
You are for petitioner,
Yes, sir.
Mr.
Mane Kunya.
Mani. Punyak. Mani. Petitions present and has no objection to the fair made by Mr. CC. Please the case accordingly. after.
Yes, Lordship.
I'd like to mention item number 26.
26, reading.
Lordship, I pray that it may come up on Thursday
Thursday, 2 millimeters, 7 fixed, no?
after week. My lord.
The prayer of Mr. Mani. Punyak. Then consider praying for a petition. Item
26.
26 already mentioned, perhaps. Okay. Now consider for a petition. Here's the case. Petitions. Not private number. Come on, have joined together to institute the present petition under Article 26 of the Constitution of India, stating that they have a common cause of action and a common defense. SLEs meet. Pre-notification. Bearing number so and so. Dated 21/7/2022. Page 28. Published by the Home Department, Police, quote-unquote, B branch, Government of Nagaland. Whereby the respondents, state respondents, published a select list containing 11 number of candidates who have been selected, who have been shown selected for the post of head assistant, post of POSTS, post of head assistant within the district comma, accountant, comma, upper division assistants, comma, welfare officer, and lower division assistant respectively. Full stop. For the two post of head assistant district, comma, the respond number 4 and the respond number 5 have been shown selected, whereas the respond number 6 has been shown selected for the post of accountant. Post of the respond number 7 to 11. Respond number 7 to respond number 11 have been shown selected for the post of upper division assistant. Post of the respond number 2 and the 12 and the respond number 13 have been shown selected for the post of welfare, two post of welfare officer, whereas the respond number 14 has been shown as the selected candidate for the post of lower division assistant. Setting aside and quashing of the appointments of the respond number 4 to 14. Come on. The petitioners have also sought for a direction in the nature of mandamus. The respondent authorities to prepare a fresh select list strictly in accordance with the terms and conditions of the advertisement dated 12/2/2020. The genesis of the list is traceable to a press release stroke advertisement bearing number page 18 WBC dated 12/2/2020 published by the Home Department, Police B Branch, Government of Nagaland, whereby applications along with all relevant documents were invited from ex-servicemen, eligible ex-servicemen, eligible ex-servicemen who were retired from Army, Navy, and Air Force, and were commissioned officers and personnel below officers rank within bracket PBOR. As the advertisement by the advertisement, applications were invited for a number of different categories of posts. Insofar as the present writ petition is concerned, the post advertised under class Roman 3 and Roman 4 within bracket the following class Roman 3, Roman N, Roman 4 within bracket non-gazette post are of relevance. Page 28 or serial number 5. 5, 6, 7, 5, the beta 6, 2, 6, 7, and 8. Right? As per the said advertisement, the last date of receipt of applications was for re-employment was 21/3/2020. So the posts are in the Directorate of Sainik Welfare and Resettlement, Nagaland, and Para. What is the mode of selection? Exactly where in the advertisement? It says about
Selection.
clause 7 says only about application for the director post, class 1. Gazetted
Yes.
officer will be shortlisted.
The last stated by Lordship, such petitions are
Hmm?
eligible for petitions for the type of interview. Which of the type it does for cumulative post conducted to assess the suitability.
So any interest was done. The advertisement mentioned that the candidates were required to produce the original documents at the time of interview. Post of written and typing test for clerical post would be conducted to assess the suitability for re-employment. The petitioners and the respondent number 4 to 14 responded to the advertisement by submitting their applications along with the testimonials. Post of. A notice for interview was published on 25/11/2021, informing that the interviews of the candidates were applied in response to the advertisement dated 12/2/2020 for re-employment of eligible ex-servicemen against the post indicated in the advertisement in the Directorate of Sainik Welfare and Resettlement, Nagaland, and in the Zilla Sainik Welfare Officers, Nagaland, would be conducted by a selection board constituted by the Home Department as per the schedule indicated therein. The date of interview for the post of POSTs, Head Assistant District, Upper Division Assistant, and Welfare Organizers were scheduled on 14/12/2021. On the other hand, the interview for the post of accountant and Lower Division Assistant were scheduled on 15/12/2021. Subsequent to completion of the interview process, the MP notification was published on 21/7/2022. By publishing a select list for appointment to the post of Head Assistant District Accountant, Upper Division Assistants, Welfare Officers, and Lower Division Assistant as follows is 28 hours. Aggrieved by this and dissatisfied with their non-selection, the petitioners have proposed this court by the instant petition seeking the relief mentioned in the book. I have heard Mr. C.T. Jamil, Learned Senior Counsel, assisted by Mr.
I am Chen, Your Lordship.
I am Chen, Learned Counsel for the petitioners. MSP should treat Learned Additional Advocate General Nagar for the response number 2 and 3. And Mr. J. Shekhi, Learned Counsel for the response number 4 to 14. Yes, is there any deletion of CGC? Any order?
Yes, Your Lordship. It was passed in an IA, Your Lordship. IA 142. Dated 5/9/2022, Your Lordship.
Where is 15 then? Where is 15?
The state is representing, Your Lordship.
You are 15. 2, 3, and 15. Full stop. This is implement of 15.
Yes,
Where is
Your Lordship.
deletion of response number 1? Any IA? Where?
IA 123, Your Lordship.
It is noticed that though the Union of India represented by the Secretary, Kendriya of Sainik Board, Government of India, Ministry of Defense, was made party respondent number 1 in a instant repetition, the name of the respondent number 1 is to delete it. From the area of respondents at the instance of the respondent number 1 itself. by an order dated 5/10/2023, casting an interlocutory application, IA Civil 123/2023. By an order dated 5/9/2022, casting in another interlocutory application, IA Civil 142/2022, the respondent number 15. That is, the Director of Sonic Welfare and Resettlement, Nagaland, has been implemented as party respondent number 15. Mr. Zamir, learned senior counsel appearing for the petition, has submitted that all the petitioners are eligible to apply for the post of Head Assistant District, Accountant, UDA, Welfare Officer, and LDA. And accordingly, the petitioners have applied individually for the post of Head Assistant District, Accountant, UDA, and LDA. As regards the selection of the respondent number 4 to 14 are concerned, Mr. Jamir has submitted that the respondent number 4, the respondent number 6, the respondent number 7, and the respondent number 14 did not meet the eligibility criteria on the last date of submission of application, that is, on 21/3/2020. As regards the respondent number 11, he has submitted that the respondent number 11 does not come within the definition of quote-unquote serviceman. And as such, the appointment of the respondent number 11 is illegal. Selection of the respondent number 11 is illegal. Good stop. As regards the respondent number 9, he has submitted that the respondent number 9 had applied only for the post of welfare organizer within bracket district. But despite he has been selected for the post of upper division assistant without there being an application from his end. The challenge to the selection of the respondent number 10 is made with a contention that though the respondent number 10 was was discharged from service as a clerk, but his rank at the time of discharge was Nayak, and he was only having the benefit of Havildar under the modified assured career progression within bracket MSCP scheme. SL is made to the selection of the respondent number 8 for the post of UDA on the ground that the respondent number 8 was though a Havildar, but he was not a clerk at the time of discharge. Full stop. It is the contention of Mr. Jamil that the respondent number 8 was only a storekeeper, right?
Yes, sir.
As regards the respondent number 5, the petitioners have challenged his selection on the ground that he was a petty officer in the Indian Air Force, Indian Navy, and at the time of his discharge, he was serving as aircraft fitter, meaning thereby, he was not serving as in the clerical capacity. Fair. MS Shukri Larned Additional Advocate General appearing for the respondent number 2, 3, and 15 has submitted that as per the explanation provided to the definition of quote unquote ex-serviceman, a person serving in the armed forces of the Union, who on retirement from service, would come under the category of quote unquote ex-serviceman, can be permitted to apply for re-employment 1 year before the completion of the specified term of engagement. As all the 4 respondents, that is, the respondent number 4, the respondent number 6, the respondent number 7, and the respondent number 14 had applied within a period of 1 year from the date of their respective date of discharge, comma, the state respondents considered their candidature for selection and finding them suitable in the selection process, comma, their names were placed in the selection list. Special consideration was given to the respondent number 11. What is her relation? Where have you
The
mentioned?
younger sister of the martyr.
Where is it exact? Yes.
Well, starting from page 57. annexure
57.
23
57.
Of my affidavit. The explanation is given at paragraph Roman 11, Mali, page 9.
C was an younger sister of late Nike N-I-K-E-Z H-A-Q-U-O K-U-O Kenbrus K-E-N-Z-R-U Z-R
Lordship, G-U-R-U-S.
where from you are reading? In the page 57A.
Wrong spelling, the actual spelling.
Which one is correct?
K-E-
Okay, Kengruse. You have typed it wrongly. 57A. You have typed it wrong.
Yes, Lordship.
Comma. Who was died a martyr in enemy action in Operation Bijoy. It is the contention of MS Sukri that since none of the petitioners had applied for the two posts of welfare organizer, advertised, comma, they cannot mount a challenge to the selection of the respondent number 12 and the respondent number 13. As regards the selection of the respondent number 9, to the post of UDA, it is submitted that the final selection for appointment was done solely on the eligibility and suitability of the candidates and merits as per mark marks obtained. Full stop. The respondent number 9 had all the requisite qualifications for being considered for a post in Group C, including the post of UDA, besides the post of welfare organizer, as both the posts have the same scale of pay. In respect of the respondent number 10, it is submitted that he was enjoying the benefits as Havildar at the time of his discharge. As regards the respondent number selection of the respondent number 4, I'm sorry, respondent number 8, it is submitted that the respondent number 8 was Havildar. And Havildar storekeeper technical clerk at the time of his discharge. And his credentials, his such credentials cannot be questioned by the petitioners. Full stop. Or if uh, 2 minutes. It is further submitted that all the submitted that the respondent number 4, respondent number 6, respondent number 7, and the respondent number 14 were in the Indian Navy, and at the time of their discharge,
4, 6, 7, 14, they are from the Air
Navy.
Force, Indian Air Force.
Indian Air Force. And they were discharged from the rank of sergeant. And as per equivalence, they are equivalent to Havildar
Yes, sir.
in Indian Army.
My lord.
By which such contentions, it is submitted that no case of interference has been made out by the petitioners. Mr. Seki, Land Council, representing the respondent number 4 to 14, has submitted in similar lines as the learned Additional Advocate General, Nagaland. He has further contended that the petitioners had participated in the selection process without any protest. And as such, it is not open for the petitioners to challenge the selection of the respondent number 4 to respondent number 14 after being unsuccessful in their endeavors for selection. Full stop. In support of his such submissions, Mr. Seki has referred, has relied upon the decisions of the Honorable Supreme Court of India in Chandigarh Administration and another versus Jasmine Kaur and others, reported in 2014 10 SCC 5 to 1 and Ranjan Kumar and others versus State of Bihar and others reported in 2014 16 SCC 187. Anything more? Any other?
There is one 2017 judgment also that is so.
Okay. And D. Soroja Kumari versus R. Helen Thilakong and others, reported in 2017 9 SCC 478.
Respectfully, my lord, one more submission that I made, that the rules of 1986, the rules of 1986 and the
He
advertisement.
has
clause.
further submitted that insofar as quote unquote ex-servicemen are concerned, their re-employment are governed and regulated by the ex-servicemen within bracket readers employment in central civil services and post bracket close rules 1979, as amended. Full stop. As all the respondents, private respondents, as the respondent number 4 to 40 are ex-servicemen and the rules had permitted them to apply for post meant for ex-servicemen within a period of 1 year from the date of their actual discharge, the state respondents were well within their authority and jurisdiction to select the respondents, all of them, more particularly, the respondent number 4, the respondent number 6, the respondent number 7, and the respondent number 14. Anything more? Any submission left to be recorded?
No, my lord.
I have, in response, Mr. Imchen, Learned Counsel for the petition, has submitted that the basic qualification in terms of the advertisement dated 12/10/2020 is to be considered and adjust as on the last date of submission of the application forms, comma, that is, comma, 31/3/2020. Full stop. Relying upon a decision of the Honorable Supreme Court of India in Sudhir Singh and others versus State of UP and others. Right. In civil appeal number 2023 and special petition civil number 12441 of 2023 within bracket Sudhir Singh and others versus State of Uttar Pradesh and others, bracket close, comma, decided on 30/10/2023. He has submitted that the candidate has to comply with all the conditions stroke eligibility criteria as per the advertisement before the cutoff date mentioned therein. Full stop. The appellants therein applied in the category of ex-servicemen after obtaining no objection certificates. But the Honorable Supreme Court has held that as at the time of, as on the last date of submission of the application forms, comma, they were employed with the armed forces, they could not be treated as ex-servicemen, right?
Yes, sir.
This is your submission?
Yes.
I have given due consideration to the submissions of the learned counsel for the parties and have also perused the materials on record brought by the parties to their pleadings. Full stop. I have also gone through the decisions referred to by the learned counsel for the parties. Full stop. Insofar as, sorry, the definition of quote unquote ex-service can be found, is found in the ex-serviceman within bracket re-employment in central civil services and post bracket close rules, comma, 1979, comma, a set of rules framed in exercise of the powers conferred by the proviso to Article 309 of the Constitution of India. The definition of ex-serviceman, comma, defined in Rule 2. Bracket heading after referred to as ex-serviceman rules. Portion. The definition of ex-serviceman, comma, given in Rule 2 within bracket C of the ex-serviceman rules came to be amended by substitution by the ex-serviceman within bracket re-employment in central civil services and post bracket close amendment rules, comma, 1986. Full stop. After amendment and substitution, comma, the definition of ex-serviceman reads as under page 41 of the affidavit in opposition of the respondent, 4 to 14. A to explanation. A. Page 41, 42, 43. Your expense same, document is same, it's same. Object heading eligibility or ineligibility of the respondent number 11. Before that. On on 18/3/2024, Kalanet Additional Advocate General Nagaland was requested to obtain the application forms of the petitioners as well as of the respondent number 4 to 14. The application forms of the petitioners as well as of the respondent number 4 to 14 have been placed before the court today, and the application forms have also been perused by the learned counsel of the contesting parties. On perusal of the application to the petitioners, it is found that they were all in the ranks of Habildar as clerks. So as such, their eligibility to participate in the selection process for the post of head assistant district, accountant, UDA and LDA are not in question. First of all, a question has been raised by the respondents. A question has, however, been raised by the respondent, learned counsel for the respondents, as regards their locus to maintain the present reputation. Para. As none of the petitioners, 5 petitioners hearing, had applied for a post of welfare officer. In the advertisement, it is welfare officer. I don't know, their selection is welfare organizer. I don't know. It is your creation. I don't. I advertised in the advertisement notification dated 21/7/2022, the petitioners challenge to the selection of the respondent number 12 and the respondent number 13. Are found not maintainable in as much as they did not apply for the said to post. That's small heading. Eligibility of the respondent number, eligibility or ineligibility of the respondent number. Para. Application forms. Give one by one. From the application form of the respondent number 11, it is discernible that the respondent number 11 in our application had mentioned that she was a younger sister of late Captain a martyr of Kargil War. The respondent number 11 had the qualification of higher secondary school leaving certificate examination. Sorry. As the qualification of BCom. Bachelor of Commerce, Honors Accounting and Finance from the Nagaland University. And is a trained graduate teacher. As she has passed a central teacher eligibility test in CTET. But none of her testimonials submitted with her application submitted in response to the notification dated 21/7/2020 goes to indicate that the respondent number 11 is an ex-serviceman, as defined in clause 2C of the ex-serviceman rules 1979 as amended. Full stop. As per clause 3, colon, reservation of ex-servicemen of the press release stroke advertisement dated, was it 21/7? 12/2, what full question. All posts were reserved for ex-servicemen who come under the definition as given in the official notification. Full stop. What is your explanation, state explanation? Which paragraph? Thus, the region shown by the state respondents in paragraph 14 of their affidavit in opposition that the respondent number 11, being a sister of a martyr who sacrificed his life for the defense of the nation during the Kargil War and was posthumously awarded Mahavir Chakra, the nation's second highest gallantry award. For selecting the respondent number 6 in violation of the terms and conditions of the press release stroke advertisement dated 12/2/2020 and the definition of ex-serviceman provided in the ex-serviceman rules 1979 as amended cannot be countenanced. Full stop. The respondent number 11 is found ineligible to even apply for any of the posts advertised by the press release stroke advertisement dated 12/2/2020. Thus, her submission of application, acceptance of her application, and permitting granting permission to appear in the selection process by the state respondents are found beholds the law. Eligibility or ineligibility of the respondent number 4, respondent number 6, the respondent number 7, and the respondent number 14. All 4 of them served in the Indian Air Force. And at the time of discharge, they were sergeants All of them were sergeants? All of them were sergeants?
Yes, Your Lordship. The respondent number 4, 6, 7, and 14. Lordship, so 7, he was promoted to sergeant, Your Lordship, acting sergeant. 7, he was promoted to acting sergeant.
7.
This is one.
Their teachers, comma, the respondent number 4, comma, the respondent number 6, and the respondent number 14 were serving as sergeants, and the respondent number 7 was serving as sergeant in charge, acting.
Acting sergeant.
acting.
Page 35 and
Sergeant,
36.
sergeant, within bracket, acting.
Okay.
Those two. In a circular number 501 dated 17/1/2013 issued by the Office of the Principal Controller of Defense Accounts within the pension from Allahabad. Certain aspects relating to ex-servicemen have been deliberated. Clause 5.5 of said circular number (501) has mentioned that for guidance, comma, what is OR? OR, any idea?
Other ranks, Your Lordship.
A guidance as regards equivalence of ranks of junior commissioned officers within brackets JCOs stroke other ranks within bracket ORS in the Indian Army, comma, Indian Navy and the Indian Air Force. Would be in accordance with the table given in Appendix Y. There. From the Appendix Y there to comma, it is found that a sergeant in the Indian Air Force is equivalent to a Havildar stroke Dafadar. The next issue for consideration is as regards eligibility or otherwise of the respondent number 4, comma, the respondent number 6, comma, the respondent number 7, and the respondent number 14. is with regard to their respective date of discharge, full stop. From the documents annexed to the affidavit in opposition filed by the respondent number 4 to 14, it is noticed that in the affidavit of opposition, the service books of the respondent number 4, respondent number 6, respondent number 7, respondent number 14 are found annexed. From their service books, in their service books, the competent authority. So those service books were issued by the competent authority recording the date of issuance as 30/6/2020. All of them were also given no objection certificates to the effect that they were permitted to register their names with employment exchanges and to appear in any competitive examination and to apply for any civil post in central state government organization. There is no dispute to the fact that all of them had actually been discharged from service on 30/6/2020. It has been contended on behalf of the state respondents, as well as by the respondent number 4, 6, 7, 14, that the explanation to Rule 2C of the ex-servicemen rules 1979 permitted them to apply for a post advertised in the press release advertisement dated 12/12/2020. As they were to be released within a period as they were to be released within a period from 31/3/2020. On a closer scrutiny of the explanation. 2. Rule 2C. It is noticed that by the said explanation, one serving in the armed forces of the Union, comma, who on retirement from service, comma, would come under the category of quote unquote ex-servicemen, comma, may be permitted to apply for re-employment 1 year before the completion of the specified term of engagement and avail themselves of all the concessions available to ex-servicemen. But he shall not be permitted to leave the uniform until he completes the specified term of engagement in the armed forces of the Union. Clause 6 of the press release stroke advertisement dated 12/2/2020 mandated that simple application in plain paper had to be accompanied by a set of documents indicated therein. Full stop. One of the documents which was to be annexed with the application was a photocopy of release stroke discharge certificate stroke book. Full stop. As mentioned above, comma, the last date of receipt of applications in response to the press release stroke advertisement dated 12/2/2020, comma, was 21/3/2020. And it is nobody's case that the last date of submission of application was extended beyond 21/3/2020. From the explanation to Rule C of the Ex-Servicemen Rules 1979 as amended, comma, it is clear that as the actual date of discharge of the respondent number 4, comma, respondent number 6, comma, respondent number 7, and the respondent number 12 was 36/2020, comma, all of them, comma, as on 21/3/2020, comma, were in actual service. The explanation does not permit to leave the uniform until they complete the specified term of engagement in the armed forces of the Union. Comma, at this stage, comma, a reference to a decision in Sudhir Singh Supra appears apposite. The appellants therein were serving in the armed forces in various capacities, at the relevant time, when an advertisement was issued by the Uttar Pradesh Subordinate Service Selection Commission for recruitment to the post of Village Development Officer. The appellants applied in a category of ex-servicemen after obtaining no objection certificates. Initially, their results were withheld for various reasons, but ultimately, they were issued appointment letters on 29/5/2019 and 27/5/2019, respectively. At a subsequent period, subsequent, at a subsequent time, the appellants were issued focus notices as to why their appointments should not be held to be a nullity. As on the last date of submission of the application forms, they were employed with the armed forces and could not be treated as ex-servicemen. The Honorable Supreme Court had observed to the effect that none of the appellants can be said to have been ex-servicemen at the time of the advertisement in question, undisputedly, they were still in service. It has been held that the appellants cannot be deemed ex-servicemen from a prospective date, despite being in actual service. On the relevant date. It has been observed that there is no concept of serving personnel being ex-servicemen, and it would not be proper for a court to hold or interpret otherwise. Justo. Espera. It is well settled proposition of law that the basic qualification stroke eligibility is to be adjusted as on the last date of submission of application forms. The candidate has to comply with all the conditions and eligibility criteria as per the advertisement before the cutoff date mentioned in the advertisement, or else, on the last date of receipt of the applications. The ratio laid down in Sudhir Singh Supra in respect of ex-servicemen is clearly applicable in respect of the respondent number 4, the respondent number 6, and the respondent number 7, and the respondent number 14 in the case in hand. The respondent number 4, the respondent number 6, the respondent number 7, and the respondent number 14 were clearly ineligible to apply for the post in response to the press release stroke advertisement dated 12/2/2020 with the last date of receipt of application as 21/3/2020 as on 21/3/2020. They were in actual service and they do not satisfy the criteria of ex-servicemen as indicated in the press release to advertisement. The press release to advertisement required submission of photocopy of release stroke discharge certificate stroke book and the service books of the respondent number 4, respondent number 6, respondent number 7, and respondent number 14 indicate that their date of discharge, common date of discharge, was 30/6/2020. As there is no concept of deemed ex-servicemen, as held by the Honorable Supreme Court in Sudhir Singh Supra, their selection to the post of head assistant district within bracket the respond number 4, accountant within bracket the respond number 6, UDA within bracket the respond number 7, and LDA within bracket the respond number 14 are not sustainable in law, and they are liable to be set aside and passed their selection. Sorry, as per a notification dated 21/7/2020, are not sustainable in law and are liable to set aside and passed. It is accordingly held. As they are found ineligible on the count of not fulfilling the criteria of ex-servicemen, the issue as regarding equivalence in rank is not required to be gone into. From the application of the respondent number 9. Please hand over. Giving it back. 11. Respond number, sorry, 10. Sorry, 9. Application of respond number 9. when the, in view of the specific allegation made by the petitioners in respect of the respondent number 9 that he had applied only for the post of welfare officer and did not apply for any of the other posts advertised in the press release. Stroke advertisement dated 12/2/2020, the application form of the respondent number 9 has been looked into. Post. On perusal of the application of the respondent number 9 submitted in response to the press release stroke advertisement dated 12/2/2020, on Madam, one more is found. Something more is found. This application is of 26 September 2021. In his own handwriting. 21 September 2021. Meaning thereby the division bench judgment and the single bench judgment will be applicable in his case. It is by pen. I thought that I will not go to that, not required to be gone into the single bench and division bench judgment. His application suffered from more defects than one. On 26/9/2021, it is found that he had only applied for the post of welfare organizer. Therefore, he has found this post welfare organizer because advertisement says welfare officer. See the advertisement. In the advertisement. Okay. I am wrong. If a candidate responds to an advertisement seeking applications, inviting applications for a number of posts, to one specific post out of the post advertised, his application is to be considered only for the post the candidate has applied for. In case of the respondent number 9, as we have found out from his application itself, comma, he had applied for specifically for the post of welfare organizer. His date of discharge was well within 21/3/2020. But the respondent of 5 did not choose to apply for any other post indicated in the press release to advertisement, that is head assistant district, UDA, accountant, etc. The state respondents, by placing a convening order, dated 23/11/2021, have sought to advance a contention that the selection board constituted for a purpose, comma, had the discretion to examine the desirability had a discretion to examine the eligibility and suitability of a candidate with reference to the eligibility criteria. Full stop. On a query. Full stop. From a simple a glance at the convening order makes it discernible that the convening order was issued subsequent to the press release to advertisement dated 2000. On a query meet to the lunch edition, comma, it is replied that the convening order does not indicate that there was any mandate to publish the same by way of an addendum stroke corriendum to the press release to advertise. No mandate. There is no mandate to publish it in the official gazette, etc. It is settled that rules of the game cannot be changed in the midstream. when a candidate applies for a specific, has chosen to apply for a specific post out of the many posts advertised, comma, it is clear that he did not opted to participate in the selection process to be initiated for those posts. Full stop. It is not open for the state respondents as the to contend that it would be open for the appointing authority to have the discussion to select a candidate according to his eligibility and suitability in respect of any of the posts so advertised, even if the candidate has not applied for the post. Filling up of a post by a candidate to which he did not apply would amount to would amount to is in violation of Article 14 of the Constitution of India. Full stop. Selection of a particular candidate for a post without the candidate having applied for the said post, comma, would deprive the other candidates in the fray who had applied for that specific post from the benefit of from competing amongst them, amongst the candidates who had applied for the post. On that ground, comma, the selection of the respondent number 9 for the post of UD by the notification dated 21/7/2020 is found unsustainable in the application forms of the respondent number 8 along with the annexes submitted therewith are perused. Full stop. The petitioners have mounted the challenge to the selection of the respondent number 8 on the premise that though the respondent number 8 was serving as Havildar at the time of his discharge, he was, where is his document? Page. He was only a storekeeper. Full stop. The advertisement the press release took advertisement mentioned that one he was selected for a post of
UDA, Your Worship.
UDA.
Yes, yes.
If one was JCO stroke Habildar clerk at the time of his discharge, comma, he would be eligible for the post of UDA, within bracket directorate stroke district. On perusal of the documents annexed to the affidavit in opposition of the respondent number 4 to 14. More specifically, from page number 47. To page 50. Page page 7 to 40. Can I have his application? As well as from the application of the respondent number 8, along with the documents annexed thereto, comma, it is discernible that he, respondent number 8, at the time of his discharge on (30/4, 2019), comma, was enjoying the rank of Habildar, and he was given the benefit of modified assured progression scheme, P progression, within bracket MSCP, bracket close, scheme. He was given the financial benefits of Naib Subedar under the modified assured career progression, within bracket MSCP scheme. And his trade was storekeeper stroke clerk. The discharge book as per the discharge. As per the discharge. He had also completed a diploma in warehousing, within bracket weapon, is it has been certified by the competent authority that the respondent number 8 was a Havildar stroke non-commissioned officer. Havildar within bracket storekeeper technical, store clerk. And a non-commissioned officer till his retirement. As per clause 48 of the discharge book, equation of his service education qualification has been made with civil educational qualification of graduate as per Government of India's letter dated 12/2/1986. In view of such credentials of the respondent number, as per the graduation certificate annexed to the application, the respondent number 488, an ex-Havildar stroke Naib Subedar with trade as storekeeper is to be considered educationally qualified for Reserve Group C post where prescribed qualification is given. In view of such credentials of the respondent number 8, his selection for the post of UD is not found to be unjustified. Whatever what heading is the DD, need to respond by equal to eligibility or ineligibility of respondent. Next to respondent number 5. The date of discharge of the respondent number 5 was, yes, Mr. Cheki, please check 31/7/2018. He served in where?
Indian Army, Lordship, which Indian Navy.
Indian Navy. In the Indian Navy. As per his service and release certificate, appended to the affidavit in opposition by respondent number 4 to 14, he was petty officer aircraft fitter. As per equivalence provided in Annexure Y, to the circular number 501, dated 17/3/2013, a petty officer in the Indian Navy is equivalent to the rank of Havildar stroke Dafadar.
Yes, Lordship.
In any view of the matter, equivalence of one post in one branches of the armed forces with another post in another branch of the armed forces is for the competent authority to examine. From the appendix 1 line to circular number 1, it is discernible that a petty officer is equivalent to the rank of a petty officer in Indian Navy is equivalent to uh, the rank of Havildar stroke Dafadar. The issue raised by the petitioner is that a petty officer, just because the respondent number 5 is a petty officer, he cannot be equated with Havildar clerk, full stop, unless a specific case is made out that the decision of the selection authority is contrary to the existing norms, a report while exercising the power of judicial review under Article 226 of the Constitution of India does not seek in appeal over the decision of the competent authority or the appointing authority. So in the case in hand, the appointing authority has found the respondent of 5 as a petty officer in Indian Navy as equivalent, having the equivalent qualification to be appointed for the post of, to be selected for the post of UD. Post of. In such view of the having regard to the ambit and scope of the power of judicial review under Article 226 of the Constitution of India, this court is not in a position to in the absence of any clinching material, is not in a position to decide about ineligibility of the respondent number 5 for to be selected for a post of UD. UDA or SD? Huh?
HA district.
Head assistant district. Head
Yes, that
assistant
is-
district. Post of. Para. Respondent number. Who is left? 10. 10.
I believe 10 is already covered now.
Ah,
12 and 13.
he is. No. I am sorry then. He was Nayak
Yes, that's it.
and MSCP Havildar. I have dealt. He is not eligible.
Yes, that's it.
No. Dealt. If
No,
not
then
dealt,
not
I'll deal.
dealt.
I'll not repeat that. MSCP, I'll deal him because he is holding substantive post of Nayak. As per Annexure Y, he is below Havildar. He is having only financial benefit under MSCP as a Havildar, so he is not eligible. Fair. The decisions referred to by Mr. Seki, the counsel for us, that's number 4 to 14. In the decisions. The principle laid down is to the effect that principle laid down is that If a person has appeared in in a selection process, knowing fully well the process, he cannot resile later on and take a somersault, saying that the procedure as adopted by the selection authority is vitiated. Full stop. If one appears for the examination without protest and files a petition only after he realizes that he would not be selected in the examination, no relief can be granted in such petition. Full stop. It is settled that if a candidate takes a calculated chance and appears at the interview, then, only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or the selection committee was not properly constituted. Most of the case in a case in hand, it is in none of the decisions referred to by Mr. Seki, the question of ineligibility of the selected candidates were doubted. Full stop. The petitioners therein were found had found themselves not successful in the selection process as their positions were below the selected candidates whose selection they had challenged. It was in that context, the principle referred again above is clearly applicable. Full stop. In the case in hand, the petitioners have contended that many of the respondents were ineligible in terms of the press notice that's advertisement dated 12/2/2020 itself, and their candidatures ought not to have been accepted, not to speak of allowing them to participate in the selection process. The petitioner's eligibility to participate in the selection process are found to be in order. In such view of the matter, the decisions referred to by Mr. Seki to buttress his submissions, is found not applicable to the facts and circumstances obtaining in the case in hand. In view of the discussion made above and for the reasons therein, the selection of the respondent number 4, the respondent number 6, the respondent number 7, the respondent number 9, the respondent number 10, the respondent number 11, and the respondent number 14 are not found sustainable in law. And as such, their selection for the post against which post of so and so are liable to be set aside and trust. So they are accordingly set aside and trust. insofar as regards the relief sought for by the petitioner by the second pair, comma, this court is, the materials are, sorry, the press release stroke advertisement dated 12/10/2000, 12/2/2020 did not mention about maintaining of any waiting list. Is no, full stop. It is not known whether there was any cutoff mark or benchmark made by the selection board in respect of the post the petitioners had applied. Full stop. In the absence of sufficient materials, comma, it is not possible to hold that the process of selection should be carried forward from the stage of setting aside and quashing of the selection of the aforementioned respondents. As a natural corollary, comma, it is left to the appointing authority yes, Sukrit. It is left for the authority to find out of the best course available, basically the best course available. Best course available to fill up the post. Right? I think it over. I think it over. Because waiting list, had it been a waiting list, we could have, but nowadays I don't think any mention in the waiting list about waiting list. And we don't know your position, whether you have failed
My lord,
or press process.
your
What do you
lordship,
say? Mr. Counsel,
my lord.
press process, Mr. Seki will be eligible now.
No, my lord, one concern, in respect of the private respondent number 5, 8, 12, and 13. What about the time period wasted in litigation, my lord? Whether any observation is necessary? to
Why?
be made?
No, the interim order. The interim order made in respect of the this 4.
5, 8,
No.
12.
The interim order made in respect of the respondent number 4. No, wait. Respondent number 4, 6, 7, 9, 10, 11, and 14 stands merged with this order. The interim order passed in respect of the respondent number 5, 8, 12, and 13
Lordship.
stand vacant. Madam, you, because I have to correct it also, you keep it with me, or one day or 2 days, I'll give all the applications now. I'll just I have to check so that typing mistakes do not creep in. But one cannot avoid.
Much obliged. Your
Much
Lordship.
obliged.
May I please, Lordship?
Yes, sorry.
Lordship, now, item 25, Your Lordship. Now, this is 2022 matter and it's to cancellation of offer of appointment to the post of constable. Your Lordship. There's urgency in this. So I pray that the matter will be listed on that such order can be as first item on 1st April, Your Lordship.
1st of April.
1st April.
No,
Yes.
Mr. Jamir,
Lordship.
one thing is that I will not be sitting on 1st April. So my brother will be sitting. So fixing the date as a first item will be difficult. I can fix the date, but I cannot fix it
Lord,
as
I am
first item.
understood.
It will be improper
Yes.
on my part.
Your Lordship. The Thursday cause list is already out. If the matter is listed in supplementary, it will not reach. And next week, only Tuesday, we have SP, Your Lordship. So, then, Your Lordship, if the matter will be listed on 1st. First April.
Okay. You are for the petitioner?
Your Lordship.
Okay. On the prayer of Mr. On the request of Mr. T.B. Jamil, Land Council, single petitioner or double?
Yeah, it's a joint petition, Your
Joint.
Lordship.
Petitioners. Petitioners raised the case on 1/4/2000, 1/4/2024. Am I Sukri, you were there?
CGC, it's a young
Of
Lordship.
Mr. Yangarvadi, Land Central Government Council for the respondents is in attendance and has agreed to the same.
Obliged.
Others are left over. Any other item then left over? Any item left? Up to the. Hey, secret judgment here is also na. Up to the both of us. Okay. Hey, to document us. Can you give it together? Together. This is response number 8.
All together, okay.
Serially.
Okay, Lordship.
Just it will waste your 5 minutes, but still. To deliver. To deliver, I can set to go on the packet. Yes, sir. It will need your matter. I can serial.